here. All right, how about now?
Yes, perfect.
Okay, and it looks like I'm not going to be able to get rid of that bar at the top, so sorry about that, guys. I tried, and apparently I keep stopped sharing at that point in time, so we're going to have to work with what we got here. So you should be seeing that PowerPoint screen now. We're going to go ahead and move forward here and talk a little bit about what today's course is going to be like. Right now we have you should have a guidebook that she sent over to you. This guidebook will be your best friend moving forward, not only today, but it will be in the future as well. It's got so many great resources in it and so many things that you're going to want to use throughout everything. As you go through it, in the right-hand corner of the slide, there's going to be a little number that tells you what page of the guidebook it's going to refer to. So if, for example, you need more information, you didn't hear something that I said, or something slightly confusing to you still, and you want to get more information on it, feel free to look at that little number on the bottom, and it'll tell you a great page to go to on that. Another thing about this guidebook here that you're looking at is that there's a table of contents at the front. It's going to tell you everything that we're going to go through today. The first two sections, we've got Introduction and Establishing IRAs and IRA Funding. Typically, we get through those two sections before we get to lunch, depending upon where we're at with things, how many questions you guys have, how many things we need to do and address from there. Then we have the IRA distributions and IRA portability sections. Those are the little more detailed section, but probably things that you deal with on a regular basis. People want to know how they get their money out of their IRA, how they move their money to another account, things like that. Then the final sections, you have a job aids section and a glossary. The job aids is by far my favorite section. If you're like me, you like to have little reminders of what's going on, how things are going to work, and just a visual aid if you're ever doing something. I wallpaper my cubicle with these job aids. They tell you all of the important information, like your modified adjusted gross income limits, your ways of moving, how money can move to and from IRAs, things like that. So the important little reminders that you're going to have a lot of questions on as you move through everything. IRA portability, again, it's how you move that money, things like that. So the job aids give a lot of information on how to move that money as well. The glossary, pretty much exactly what it sounds like. Anything you want to know, where is it in the book? It'll tell you there. And then the last section, I want you to refrain from looking at this section until we are done today. So this is the exercise master. As we go through this, I'm going to ask you a lot of questions. And I'm going to say, what's your answer to this? You can chat in those answers and give me that information from there. I don't want you to use this exercise master to cheat and steal those answers without trying to apply yourself. So please try to apply yourself and get those answers yourself. Then later, if you need to remember exactly what that wording was on that answer, you can look at that exercise master. So today we're going to get through everything. We're going to take about a break midway through before lunch. Probably take lunch around 11:30 to 12, depending upon how fast things go. If you guys want, we can take a shorter lunch, and we'll kind of judge it by when we get to that point in time, see how much time you want. And we could take a shorter lunch and then you're done earlier, or we can just go straight through, have that hour lunch there, depending upon what you want to do for that. So that's the basis of what we're going to be doing today. Remember to chat in any questions. Unmute yourself if you have any questions too. You can always use that reaction button to let me know what you're dealing with as well. So let's go ahead and get started here, but I do have a question I would like you guys to go ahead and send over to me. Not send over to me, if you don't mind, chat in with your voice. So unmute yourself here, because like I said, there's a little bit of a technical issue with the thing not allowing me to look at both the chats and the other feature there at the same time. So if you could just vocally let me know what's going on. My question to you guys is, how many of you have been working with IRAs for 10 plus years? If you have, just go ahead and unmute yourself.
We have one person in the room that have.
Okay, one that has. Anyone
We
else?
have one here too. Yeah, we have one in our room too.
Cool. All right, what about you guys that have been working for 5 or more years? Not to 10, no, 5 to 10, in that range.
Another one in this room.
Okay.
I'd say
And
that I have.
you have, okay.
Yeah.
What about in the 1 to 2 or 1 to, we'll say 1 to 4 range, in that range?
Yeah, we have a few in this one.
All right, what about you guys just got told this morning or, you know, a couple days ago, hey, by the way, you're going to this seminar and you're going to be our new IRA expert. All right, no official newbies. Okay, sounds good. So everybody has a little idea of what we're dealing with here, but the basic, we're going to talk about all of the basics you need to know about IRAs. So anything from contributions to the distributions to those important things that you're going to be dealing with on a day-to-day basis. How many of you, your only job is going to be working with IRAs, or your sole focus is IRAs? Anyone?
Nope.
Yeah, most of us have a lot of titles underneath us. Most of us do a lot of things. So whenever IRAs come up, they tend to be a little bit of a heavier topic and we get a little nervous. I hope to, by the end of this, make it to where you guys aren't as nervous whenever we get through this. So I want you to, on a scale of 1 to 10, and this is for yourself personally, I want you to rate yourself where you feel like you are on the IRA scale right now, what your knowledge is personally on that IRA scale. If you want to share, feel free to. If not, that's fine. This is just for your reference. By the end of the day, I want us to have improved that number on that scale. So if you were a 5, you now feel like you're a 7 or something like that. Okay, so we're going to make it to where you feel more comfortable when you're dealing with IRAs. If nothing else, you have this wonderful book as a handy dandy reference guide moving forward here. So I also want you guys, if you're starting to feel a little tired, need a break, go ahead and let me know too as you move through this. Now, our first section we're going to be talking about here is the introduction in establishing IRAs. After completing this section, we are going to feel a lot more comfortable in how to actually open an IRA. What are those tax advantages of traditional and Roth IRAs? Why we would want to open them? We're going to talk about those opening document requirements. So what do we need to make sure that IRA owner has in order to open that IRA? Make sure it's an official IRA. We're going to also talk about the difference between primary and contingent beneficiaries. So whenever an individual is leaving their money to someone, how do we make sure it goes to the right person that they want it to go to? What are those beneficiaries and which type should they be having each individual under there moving forward? So there's a lot to talk about in this section alone here. First, IRA. Does anyone know what an IRA stands for? If you do, you can go ahead and chat in.
Individual retirement account.
Okay.
Right.
Anyone else? So it does not stand for I run away. Do not run away when you hear IRA, okay? It does stand for individual retirement arrangements. So that's the technical IRS term. Now, what they mentioned was individual retirement account. That is a very typical one that you're going to hear about. There's actually two different types of IRAs. You have an individual retirement account and an individual retirement annuity. But the technical IRS term is going to be individual retirement arrangement, and it describes both of these types of tax advantage saving tools. Now, these are designed to provide retirement income in addition to the Social Security income, employer-sponsored retirement plan income, personal savings, and wages that they might already have here. So whenever you're thinking about retirement, nowadays, what you deal with is individuals need to draw from a lot of sources. People used to only rely on that Social Security income, but now that Social Security income is not feeling as stable as it was before, right? We hear on a, maybe not daily, but a regular basis that Social Security is dwindling. We're not going to have any. We might not have as much, things like that whenever we go to retire. So what you see is a lot of individuals will have multiple sources to draw from. And IRAs are going to be one of those sources. So where you could have individuals still working at a later day in life where they've got those wages, they have an IRA, that's one source. It's a tax advantage saving source they could draw money out of. Now, IRAs can only be in one owner's name in particular. So whenever you think of individual retirement arrangement, I stands for individual. That means it is for that one person only. We cannot have a joint IRA. A lot of people think that, hey, this is for me and my spouse, so it needs to be in both of our names. That's not possible. It has to be in one person's name, one person's tax identification number as well. Now, retirement means exactly what it sounds like. What I mentioned earlier is that it is specifically designed for retirement, to aid you in retirement. So in other words, they have certain rules to try and keep the money in their retirement account, as well as to try and increase those taxes and some benefits depending upon what type you choose if you wait till later in life when you take the money out. So it is designed to aid in retirement. They want you to keep the money in that account there. Arrangement. Now this is referring to, you have multiple types. As I mentioned, it could be an account or it could also be an annuity there moving forward. So it's important to note that an IRA, an arrangement there that we're dealing with is not an investment. It is actually an account or a trust there that we have built. So individuals can establish actually multiple investments underneath one individual retirement account. That's something we see pretty regularly, is that individuals, whenever they're starting with IRAs, they think that you need to open a new IRA for every investment that that individual has. That's not the case. We can have one IRA and have multiple types of investment under that same IRA. You could have a savings account under one IRA, a one-year certificate, anything like that, the money market account, any other type of investment you might want under that one IRA, and it's still okay. So I want you to think of an IRA as an umbrella. What does an umbrella do? Well, umbrellas shelter you from the rain out there, right? They make it to where anything that's coming down from the sky, we're not going to get hit with, right? Think of the IRA, individual retirement arrangement, as the same thing for your money there. It is sheltering all that money from the taxes that you might have to pay on a regular basis there. So you're not going to have a 1099 that you're INT that you're dealing with. You're not going to have anything like that. Instead, you get to wait until you take that money out to pay the taxes on it. So it's a way of not dealing with the taxes until later in life. It shelters you from that type of money that you might have to normally pay if you had it in a savings account. You know, at the end of every year, you are supposed to report how much money you had in your savings account that gained interest there. Same with any other investments that you have. You're supposed to note the amount of interest that you've gained over that time period. So it shelters you from that. As I mentioned, there are two different types of IRAs. You have an individual retirement account and an individual retirement annuity. Most of you are going to have dealt with individual retirement accounts only. I would say for probably all of you. If anyone else has dealt with any individual retirement annuities, feel free to chime in. But for this course, we're pretty much going to stick to the individual retirement account terminology there moving forward. The only difference between the two is pretty much terminology that you're dealing with and who offers it. So in other words, most accounts you're going to see financial organizations, banks, anyone like that. Annuities typically are more credit union based, and what they are insurance companies. You'll see a lot of that too. The types of investments offered will also vary. But like I said, the biggest one is going to be that it's those different terminologies. If you want to see the difference in the way things are worded, you can look at your book there. It's going to be on page 2 of that book, the guidebook, letting you know the differences. So notice an issuer is the name for the annuity, the person that gives that annuity, offers that annuity, whereas you're dealing with a trustee or custodian there whenever you're dealing with an individual retirement account. Typically, they're subject to the same rules. One of the big things that are different might be that distribution process, how the money is distributed over time, okay? So throughout time, there have been a lot of law changes that have occurred that have resulted in changes to these IRAs, made things different, and either increased the benefits of IRAs or just totally added new items to it. Traditional IRAs first became available in January of 1975. Now notice here that 1974 ERISA is what actually established that process. They allowed for traditional IRAs. You typically see this when you're looking at those law changes. You see that it might be the year before that the actual law change is titled with. Following that time period is when it actually began. So like the example here, the Employee Retirement Income Security Act of 1974 established traditional IRAs there in 1975. In 1997, you're dealing with that Tax Relief Act of 1997, but it established Roth IRAs for 1998. So that's when the first one could begin there. If you look at your page 4 then in your book, you see that there is an entire list of all the different tax law changes, the legislative history of those IRAs, and all the things that made changes to the tax laws that you might be familiar with. EGTRA was a big one. It had a lot of things that happened with it that made changes to those IRAs. And then PPA is another one. The Pension Protection Act was another one that made a lot of changes whenever you're moving money. Now, the two most recent law changes are going to be the FCAA and the CARES Act. FCAA, you might be more familiar with hearing the term Secure Act. That's what happened here recently. It increased that age limit for traditional IRA contributions. It also increased the age for RMDs. The CARES Act was something that was strictly for those coronavirus changes, anything like that, that made additional things for coronavirus. They were trying to help us and aid us in the things that might occur because coronavirus was around. And in turn help us be able to use our retirement account if we needed to for that same purpose there. So what are the benefits to a financial organization for having an IRA? Well, if you have an individual there that has an IRA, let's talk about first how long you have been saving for retirement. So anyone, you can go ahead and verbally say that for me. Give me a couple numbers. What are the number of years you've been saving for retirement? Or not even number of years. What age did you start saving for retirement? I'll go ahead and start the ball. That way people know that, you know, it's okay to have started later too. I actually didn't even start saving for retirement until I think I was 26. So I started a little later than a lot of you. But yeah, go ahead and let me know how long you've been saving for retirement.
About 6 years for me.
Okay, great.
I'd say 25 years.
25 years, awesome. All right, so see, there's a broad range there. Go ahead, who is the next person?
I think that was probably like 10 years ago, maybe 11.
Okay, great. Yeah, so definitely a big range here. Now think about it. So say we started, we'll use my age for example, started at 26. If I'm saving until retirement, and we'll use just the typical RMD age, there's 72. That's almost 50 years I'm saving in that IRA. That means that's 50 years your financial organization could have that one account. That's that stable long-term assets, money you know you have there. You're used to having that in your account. As long as you keep that relationship with the customer, they keep the money with you, it's always going to be there. It's that steady long-term asset there. So see, IRAs provide that great advantage is that typically when people start, they're not going to be retiring the next year. They're wanting to build that money over a long period of time. So we even had one person say 26 years already. That's already a long period of time that they've had that IRA. So hopefully, you know, if it's with your financial organization throughout that entire time, it's a great advantage for you. And because they're with you that entire time, you build a relationship with that customer. You have this great relationship with them that whenever they think of needing money for one source or another, or needing a place to save their money, they're going to think of you first. So for example, whenever you're looking for a home loan, well, the first person I'm going to think about is the people that I bank with. You know, if I've got my IRA with them, I'm going to think of them first in order to move forward on that. Also, it's important to know that if you're not offering it, no, someone else is. So they're going to take their money somewhere else and try and get that relationship with that other place. And then they're always going to think of that person first, or that financial organization first, instead of your organization. So it keeps you competitive in the market, because IRAs are very prevalent and needed in today's society. You know, they are something that is very much needed for that long-term future that we're talking about there. So what is the point for an IRA owner? What are those advantages that they're going to get out of it? Well, it's important that whenever you're dealing with the customers that you deal with on a day-to-day basis, we never give that tax advice whenever we're moving forward. But what you might want to do is you might want to be able to inform them of what are the rules behind each type and what makes it more beneficial, you know. So what makes a traditional IRA advantageous moving forward? Well, with both types of accounts, we've always got both traditional and Roth. We've always got tax deferred earnings there. So we always have that. So like I mentioned earlier, We don't have to report at the end of the year, hey, here's the interest earned on this account. No 1099 INT. No paying taxes each year on that interest earned. So what you see is those dollars. Say I invested $1,000. They earned interest of $100 each year. Moving forward, I don't pay that until time of distribution. So I'm not dealing with noting those that tax information, that taxable income each year. Not responsible for it. Great advantage there. So we get to wait until later in life to have to pay those taxes. There is a tax credit that is possible for both the traditional and the Roth IRA. There, if you look at your job age, there is a area there that will talk about the different tax advantages. I believe it's page 7 there. It might be page 6 too. Double check on that for me, but it tells you who gets this tax advantage of having that tax credit. So whenever you think about it this way, what is the difference between a tax credit and a tax deduction, which we'll talk about shortly? What you're dealing with is that a tax credit goes dollar for dollar towards the amount of taxes you owe. So I'm going to use an example of $100,000. Say I owe $100,000, or my taxable income is $100,000. Because of that, I have $10,000 worth of taxes that I'm going to owe that year. And I'm just doing these rough numbers where they're even to where you all can see. The possible tax credit that you could receive is going to be a maximum of about $1,000 there on the first $2,000 worth of income that you have, that you include in your IRA. So if I have a $1,000 tax credit, it's going to change the amount of taxes I owe from $10,000 to $9,000. Okay, so pretty significant change there. It's dollar for dollar there that you're going to be dealing with. It makes it a lot easier to handle moving forward there. A lot less money you're going to be paying in. Now the form 8880 is going to be beneficial for claiming that credit. It goes over that information on who's eligible for it to determine if they're eligible for that tax credit. It's not your responsibility to determine it. I haven't talked to a competent tax advisor there. Moving forward, they should be able to help them apply for that, make sure it's included if they're eligible for it. The tax credit, because it's so advantageous, they only allow it for individuals of a certain income. So if you're not making as much money, it would be more available to those individuals rather than the people who are in the higher income bracket there. Now, the tax credit is a possibility, as well as the tax deduction. Now, the tax deduction, what it does is it reduces the amount of taxable income you have. So if I have a $100,000 taxable income and I get a tax deduction of the full $6,000 that I contributed, I'm now saying that I only have a taxable income of $94,000. And then you're going to multiply your tax bracket times that, and that's going to be the amount that you actually owe. So in this example here, we used a 10% tax bracket, even though, you know, it might not be possible. We're just doing it to where it's even numbers. Whereas a tax credit would give us that $1,000 deduction or tax credit and make it $9,000. A tax deduction of even the full $6,000 contribution would leave us with that $9,400 taxes. So see, the credit gives you more than the deduction does. And this is something that if they are curious, if they are eligible for a tax deduction, I'd recommend, again, talking to a competent tax advisor. Also, they could consult the instructions for the Form 1040 or Publication 590A that talks about that information. You also have a chart in the job aids that you can refer to that will go over that information as well. I think it's on page 8 is what you're dealing with there. So that's what you should look at for the tax deduction. It kind of tells you if you fall into this range, you're eligible for this amount of money moving forward there. So those are the advantages of a traditional IRA. That's what we're dealing there with a traditional IRA. Now let's talk about those tax advantages of a Roth IRA and why we might want to have a Roth IRA. Well, same is true for Roth IRAs, that they're always tax deferred. The earnings are always going to be tax deferred, as well as we have the same true of having a saver's credit possibility. So if we are of that lower income, we could get a possible tax credit. The difference between traditional and Roth IRAs is this last option. So while traditional IRAs have a tax deduction possibility, Roth IRAs have another third option, and that is a possibility to get them tax-free. So this is a great thing here that they could possibly have those tax-free earnings. So remember we talked about we don't pay the taxes on the earnings that we're making there in the beginning. Roth IRAs have the possibility to never pay the taxes on it. I don't know about you, but I enjoy free money, and that's pretty much what this is you're not having to pay the government because you made this money. You are getting it free. So it's in the clear. So our account earns this interest for us. And in turn, because it's earned the interest, we normally have to pay taxes on it if it's in a money market account or anything like that. But with Roth IRAs, as long as we meet certain eligibility, we've had it in there for a certain amount of time. And the reason we're taking it out is for a reason they deem acceptable. We get it tax-free. So this is something that's one of those great sources to have for if you're wanting to leave your family money later on in life and you're not using your retirement account. This is a great way to give them that money where they don't have to pay taxes on it. So they're not going to be stuck with a hefty tax bill because they received this money. So it's a great thing there that you're dealing with. So like I said, the big difference being Roths, we get the possibility of that free money, and traditionals, we are going to be subject to the possibility of having that tax deduction there moving forward. Now we're going to do a few questions here. This is going to be on page 7 that you're dealing with. So IRA tax advantages and what you're working with there. On those IRA tax advantages, I want you to go ahead and if you could, just verbally let me know what your answer is to this. Isaac has a traditional IRA and a Roth IRA. Will the interest earned on his IRAs be included on his Form 1099 INT?
No.
Correct. Yeah. Everybody else agree with that? All right. You're exactly right there. It will not. The next one's going to be Adam has a traditional IRA and a Roth IRA. Which IRA gives him the opportunity to possibly take advantage of the saver's credit? Anyone? Which one gives him the opportunity to take advantage of the saver's credit?
Both.
Exactly. Yes. Kind of a tricky one because it doesn't give you the option of both, but yes, circle both. Both give you that saver's credit possibility there. Next one, Julie has a traditional IRA and a Roth IRA. Which IRA gives her the opportunity to possibly withdraw her earnings tax-free? So in other words, exactly, free money, Roth IRA. And you will notice as I go through this, I'm not biased, I swear, I just really love Roths, okay? So if I get a little excited when I talk about Roths, I do apologize, but I love free money. So can Judy now take a tax deduction on her regular contribution made to her traditional IRA?
We're gonna go with a maybe.
Very good. Yes, maybe. Why? Because we don't know her situation. We don't know what income bracket she falls into. We don't know if she would be eligible for that tax deduction. But we do know it is a possibility with a traditional IRA. So if you look at that income bracket, you might know, but it's not your responsibility to determine, is it? It's that IRA owner's responsibility to determine if they're eligible for the tax deduction. So when talking through those, if somebody were to ask which type of IRA should they establish, I'd say, you know, that's something to talk about with your competent tax advisor, but I can tell you some of the advantages of both. Both traditional and Roth IRAs, you have that saver's credit available to you and tax deferred earnings. If you're wanting more of a savings advantage in the current, you might have the possibility of a tax deduction with traditional IRAs. So it would give you the advantage of not paying taxes now in that traditional IRA. Whereas a Roth, if you're looking for more of a long-term tax advantage, well, you might have the ability to never pay taxes on that interest earned with a Roth IRA. So typically, if an individual is looking for current tax help, they'll go with the traditional IRA. If they're looking for a long-term tax advantage, a Roth IRA. That's just typically what you see there. So in other words, at the end of a tax year for those self-employed individuals, they might come in knowing they need a tax deduction because they're going to fall into too high of a tax bracket. So they'll make a traditional IRA contribution. A Roth wouldn't help them because they don't have that tax deduction advantage. So that's what you see there whenever you're dealing with the typical customers coming in a way that you can help them without giving them tax advice. We always provide that information, not actually tell them which one to do. So when establishing an IRA, the first thing we're going to do with that prospective IRA owner is to provide that information without giving that a tax advice. So like we talked about, we identify the type of IRA which the individual wishes to establish, and we explain those rules. We don't tell them which one to do. We don't apply it to their individual situation. So if the individual comes in and says, hey, I really need a tax deduction on this side of things, on this year's taxes, which IRA should I establish? You don't say, oh, well, you should definitely establish a traditional IRA. That's what I would recommend. You would more so say, well, the rules behind them are you don't get a tax deduction on a Roth IRA. You might get one on a traditional. Which one would you prefer? You know, that kind of thing. We also want to be able to describe those investment options that are available for your financial organization. So everyone offers different investment options. Everyone offers a different advantage for a certain investment. So be able to know those options and explain them in detail if a person asks anything about it there. Those are the important things that you're dealing with. The next step after being able to answer those questions that individuals have is we're going to need to provide important documents to that IRA owner. There are 3 documents that you are required to provide when establishing an IRA. Without these 3 documents, you do not have an IRA. This is important to know. You do not have an IRA without these 3 documents. Remember that, okay? So the 3 documents we're referring to are a plan agreement, disclosure statement, and financial disclosure. These are IRS required documents. The way I remember these and the way I remember what those 3 documents are is whenever you look at what letter each of these start with, it's PDF. And no, that doesn't mean we need that Adobe Acrobat version of this. No, that's not the case. It's PDF to remember the initials for it. So plan agreement for P, disclosure statement for D, financial disclosure for F. So we always have to have that PDF moving forward whenever we open an IRA. One PDF means one IRA established. Remember, I told you you can have multiple investments under one IRA. Well, if they fill out one PDF and they have a savings account and a money market account there underneath it, then they only have one IRA. And that's something you're going to need to know moving forward, because that helps determine how your reporting works as well. So it is very important to always know, okay, well, we've only had one set of opening documents, therefore we only actually have one IRA, even though they have 29 investments underneath it. Okay. The other additional documents that might be required, or on a lot of people are required from your financial organization, is going to be that application. So what this does is it gives you that information that you need to know about the IRA owner. First, the customer identification process. It gives you their tax ID number, who they want as their beneficiaries, all of that important information that you need to know when establishing an IRA. Just not technically required, which has always been interesting to me. You might be able to provide it another way there, but it's not an IRS required document. Most financial organizations do require that. The additional things that you might have are regulatory documents. Those are going to be things like that truth in savings disclosure and the customer identification program disclosure. So all of that disclosure information that you might need to let them know. That way they have it on file. That way they know that information moving forward. Once each party has signed and received the required documentation, an IRA has been established. At that point, the IRA is ready to be funded, okay? So you have to have each party sign this information. So that means the financial organization and the IRA owner have to sign it in order for it to be an official IRA moving forward there. So as we talked about, that IRA application is going to gather that IRA owner's information there. What you're dealing with would be the legal name, the tax identification number, the address of the individual, date of birth. Why is this information important? Well, I'm going to give you an example from my past. I used to live in the Sullivan, Missouri area. At that point in time, my name was Elena Hannikin. In that same town, there was another woman named Elena Hannikin. So if we just put down my name and the place I lived, the city I lived in, technically she could have come in and withdrawn my money. That's the only information they have. All they have is my name, period. Same thing. Now, if you have that tax identification number, obviously that's specific to the individual only. Same date of birth and same address. The other Elena Hannikin was significantly older than me. So it's important to note then that that date of birth would also vary there. So it helps distinguish what individual is actually establishing that IRA to make sure the money goes to and is reported to the correct individual moving forward. So it is very important to have this information. That's why most financial organizations will require it to accurately administer that IRA and whatever request the IRA might have, owner might have moving forward on that information. So when you look at it here, this is our IRA application that we have. Part 1 is that IRA owner's information. And part 2 is going to be that IRA custodian's information. So part 1, who is establishing the account? Part 2, that's your financial organization's information. If you are on IRA Direct, this will already be filled out for you on part 2. So you don't have to worry about that part. But if not, then you do have to fill out that information there. The next part you're dealing with is going to be those primary beneficiaries and contingent beneficiaries. So let's talk a little bit about what a beneficiary is. When establishing an IRA, that IRA owner may wish to designate people they want to receive the money if they were to pass away. Okay, so what this means is I didn't use up all of my IRA. I don't want the money to just go to whoever. I want it to go to someone in particular. And who is that person? That would be the person benefiting from my IRA if I were to die before I spent all of my money. There are two types of beneficiaries that you can do on this. One, primary beneficiary. Two, contingent beneficiary. You can allow them to name as many primaries and as many contingent beneficiaries as you want. You have those multiple levels that they can do. It's important to note the difference between the two here. So as we mentioned, I wasn't very retirement savvy when I first started out in the workforce. Y'all heard my bio. I was an English major, had a master's in creative writing. So I worked as a copy editor for several years there before I actually got into the retirement world. So I was a writer there and a copy editor and did things like that. Whenever I had my first job out of college, I was actually a tutor in English there, so out of college as well. So I remember filling out my beneficiary information and for my retirement account at that point in time. And I filled it out noting my primary beneficiaries. Well, at that point in time, I wasn't married, didn't have any kids, didn't have anything like that. So I named my parents as my beneficiaries. You'll hear me refer to my parents, Bill and Kathy, a lot as we go through this. So at that point in time, I wanted my parents to be able to split this 50-50 if they were to be alive still when I passed away. So what I did on my beneficiary form is I put my dad as primary beneficiary, and I noted 50%, and my mom as contingent beneficiary, because that's what that means, right? They split the two. No. Primary beneficiary is the individual that's going to receive the money if they are still alive when the IRA owner passes away. So in the case of my example there, my dad would have received 100% of my retirement amount that I had, which at that point in time was zero. But the point is, he would have received 100% there. My mom, on the other hand, because she was named as a contingent, would have only received the money if my dad passed away prior to her, prior to me passing away. So in other words, my dad would have passed away first, then me, then my mom would be able to receive all of that money there. So they must survive that IRA owner in order to receive a portion of that. When it's designating multiple beneficiaries, each beneficiary is going to receive a part of that balance there moving forward. So if you're looking at it, you would think of it in this manner. When I said that I gave them 50-50, but I had them on the wrong lines. If I would have put 50-50 all under primary beneficiaries and then put my brothers under contingents, Billy and Brett, then they would have received the money only if my parents predeceased me. So we always want the total amount of both the primaries and the contingents to add up to 100%. We'll use my 4 family members there when talking about it. So if I list Billy, Brett, Mom, Dad, all under primary beneficiaries, each one gets 25%. That equals 100%, right? Well, let's say we now are doing it where my primary beneficiaries are just my parents. Each one gets 50%. And then my contingent beneficiaries are my brothers. Each one gets 50% there. Or let's say Billy gets 60, Brett gets 40 because I was mad at him the day I filled out that application. So that would be the contingents there. So Billy and Brett as contingent beneficiaries would only receive that money if my parents predeceased me. So let's say that's the case. My parents predeceased me, and Billy and Brett are going to split that. If they're both still alive, whenever I pass away, Billy would get his 60%, Brett would get his 40%. If they're not both still living when I pass away, if Billy has predeceased me because he is the oldest, and Brett's the only one living, he would get the full 100%. Same would be true if both of my parents were not still living. My dad was the only one living at the time. He would get the full 100%. We wouldn't go ahead and go to contingents. No, it just, instead of him splitting it with my mom, he now gets full 100%. Okay. Does that make sense? And it is important here in this area to try and get them to put the percent designated. Like I said, we want that to make sure it adds up to 100%. It's not valid unless we get that amount. And then as much information as they can provide, the tax ID number, date of birth, things like that, relationship. Those are all important information. As much as they can provide on that area, it is important to do that. So now we're going to do some examples here. It's the beneficiary designation form. And what I'm going to do is I'm going to give you 2 minutes here to go ahead and do this on your own. And then we're going to get back together and I want you to tell me what your answer would be on each of these. Okay. So this is on page 13 there of that guidebook. All right, so go ahead and do all the questions here in this section and then we'll get back together here in 2 minutes. So mine says 9:58. We'll get back right at 10 there to answer these questions. All right. So the question is, Merrill has opened an IRA at your financial organization. He has listed the following beneficiaries. Vicki as primary, 75%. Julie, primary, 25%. Judy, contingent, 60%. Ashley, contingent, 40%. If Merrill dies before any of his primary or contingent beneficiaries, what percentage of the IRA will each beneficiary receive? Anyone?
They will each receive everything according to how it was outlined up top.
Okay. So what would, in this case, Merrill dies before any of his primary and contingent beneficiaries, we've got Vicky and Julie then getting the money, right? Vicky 75% and Julie 25%. So that leaves Judy and Ashley with 0. Now, number 2, if Vicky dies before Merrill, but Julie, Judy, and Ashley survive Merrill, what percentage of the IRA will each beneficiary receive?
Julie should get 100%.
So Vicky's estate would receive 0 then, because she had predeceased the IRA owner. Julie gets 100%, and Judy and Ashley get 0 because they were contingents. So they don't get the money unless all primaries predecease the IRA owner. If Vicky and Julie, so both primaries, die before Merrill, but Judy and Ashley survive Merrill, what percentage of the IRA will each beneficiary receive?
Judy gets 60% and Ashley gets 40%.
Very good. So the estate 0 and the estate of Julie 0, and Judy gets 60 and Ashley gets 40. Because both primaries predecease the IRA owner, they get 0. Judy would get her portion because she's a contingent, and Ashley would get her portion because she's a contingent. Now, this one's not in there, but say Judy predeceases as well. Who would get the money then?
Ashley would get 100%.
Perfect. Yep, you're exactly right. Ashley would get 100% there. So great job, guys. Spousal consent here is our next section. Now, what is spousal consent? Well, some states have these community and marital property laws that govern the property rights of married individuals. So what that means is they say that if you're married at the time of having this money, then you have to share it automatically with your spouse. A portion of it's automatically considered your spouse's. So if you were to die and you had an IRA, then a portion of this should automatically go to your spouse because it is their money. Beneficiary designation forms, they may allow a spouse to waive that community property rights to the money. So in other words, this only really matters if you are wanting to name someone other than or in addition to your spouse as the beneficiary. And you fall into one of these states here listed on the form. The blue ones here that you see, Arizona, California, Wisconsin, Washington, all of those have community or marital property laws. So those laws would affect who would get the money if the IRA owner were to pass away, even if they name someone else. Alaska, South Dakota, and Tennessee, they have elective community property laws. So that means that they would be responsible for, the IRA owner would be responsible for determining how they want to handle those laws at the time of doing that, of establishing that IRA, of moving forward. So if they want to be part of community property laws, they would decide that at that point in time. Why is spousal consent important? Well, we want to make sure that the person, the IRA owner, wants to get the money, gets the money. Okay, so let me give you an example. Whenever I was working on the IRA lines there, where we receive these consulting calls from financial organizations, I received a call from a financial organization that they were a very small community, and it was just a wonderful little community. They knew everyone there in that area. Well, the person calls in and she says, so I have a problem. I'm like, okay, what's going on there? And she goes, well, John named someone other than his spouse, Susie, as the beneficiary of his IRA. And I just don't really know what to do about it. You know, Mary's his wife. Susie is a neighbor down the street. And I mean, I've heard things about them getting together, you know, but to name it other, should I let Mary know? I feel like I should really call Mary and tell her that she is not the beneficiary of the IRA. Nope, that's not your responsibility either. So note that while spousal consent is important, if that individual signed off on the spousal consent and saying they could name whoever they wanted, that's all that they have to do. They don't have to know who that individual was. They did their part there. So do not please be the one to break up that marriage and handle that. That's not on your side of things. Do not disclose that information. It is important to note that it would affect the individual moving forward with spousal consent. So say John did not name Mary, his wife, as the beneficiary. If she signed on and they lived in, for this case, we'll say they lived in Wisconsin. They lived in Wisconsin and Mary didn't sign this form here noting that she was okay with it, then it would probably end up in court there at some point in time because Susie receives the money and not Mary. And they would probably contest that because they should receive a portion of it according to state law there. So here's the spousal consent section. Notice that it only is important if the trust or the residence of the IRA owner is in a community or marital property state, okay? So spousal consent should only be considered if either the trust or the residence. So in other words, the IRA is located in a community or property state, or the residence of that IRA owner is. Now, if they are married, they would check I am married, and then they would have that spousal consent underneath there. If they are not married, they check I'm not married. It doesn't really matter in this section. They don't need obviously a spousal consent because they have no one to have signed that. So it is important to have that IRA owner's response there. I know a lot of financial organizations say, well, what happens if they move to a community property state and they weren't previously there? Well, you know, at that point in time, they might then need to have someone other than their spouse designated. So let me give an example, the 2 times that this would be important. I'm going to use my husband and my daughter, for example, on this. My husband's name is Wesley or Wes, and my daughter's name is Blakely. And at the time of, we'll say at the time of doing this, we were still living in Arizona there, which is a community property state. And if that were the case, and I wanted my husband and my daughter to split it 50-50, then I would need my husband to sign off on this, noting he's okay with that moving forward. If I wanted only my daughter to receive the money, and not my husband, again, I need his signature. If I was only naming my husband, Wes, as the beneficiary, there's no reason for spousal consent there because I'm not naming anyone other than him. So a lot of people worry, well, what if I have him sign on this section here and he's the only one receiving the money? Does it mess him up? No, it doesn't, because pretty much what this spousal consent is saying is if someone other than or in addition to me gets this, I'm waiving my rights to the money to where my daughter Blakely could get her share. I'm saying, okay, whatever Elena designates on this, I'm okay with moving forward. So that would only apply if someone other than or in addition to the spouse were to get that money. There is that witness section. That's not a requirement, but it is beneficial because, you know, what if somebody else was signing for them? You know, in this day and age, we have a lot of things where we have to have it signed and then sent in. You know, it's something to make sure that it's in the clear. Note that it is important with that witness thing. It's not a requirement, very beneficial. That way there's no argument on it moving forward there. Now here is at the bottom of our trust application, it is the signature section. Remember I said, without a signature, there is no IRA. It is a binding contract. So with a contract, we have to have both parties sign, both the IRA owner and the beneficiary. Without those signatures, we do not have a contract and we do not have an IRA there. So it is important to have both of them sign that there moving forward. So Whenever we're opening up a IRA, we have different forms that can satisfy different things that we're dealing with. The first section being the plan agreement. Typically speaking, people use the model IRS document. This would be the 5305A, 5305 for that traditional, or 5305RA, 5305R, or RB for a Roth. You also have the option of having that prototype document. The prototype document would be something that has official approved language from the IRS. In addition to, they have some customizations on there that they might want to do there. But these are the different documents that can be used for a plan agreement. The different documents that can be used for a disclosure statement are going to be the publication 590A and publication 590B, or a disclosure statement provided by a forms provider. Most people use a forms provider disclosure statement. It is acceptable to print off a copy of that publication 590A and publication 590B because it does go over all of those rules with them too. Financial disclosure, most people will do this from their forms provider, so that is provided to them. If anyone actually does use the publication 590A and 590B for that disclosure statement, go ahead and chime in and let me know there. I'd love to hear, because I don't hear very many people that actually do that. But yeah, so typically speaking, you see a lot of people, most people go with the model document. Why? Because prototypes on that plan agreement will require you to pay a fee for. Model document, you don't have to do that because it's directly from the IRS there. Now, our plan agreement is our contract. So I mentioned you have to have that contract between the two. It is agreement between the IRA owner and the financial organization saying, here are the rules. This is what we're agreeing to follow. Okay, we're agreeing that all of these rules, the financial organization will follow their side, and as an IRA owner, I'll follow my side there. Both parties must enter into the agreement by signing either the plan agreement or application. After that document is signed, the financial organization must provide a copy to the IRA owner, retain a copy of that signed statement, or retain a copy of a signed statement noting that the IRA owner agreed, they saw that, they received that plan agreement, and they agreed to it. So they have to either keep the actual plan agreement or something noting that they received a plan agreement in that IRA owner's file. And then they have to amend that document as required. So this is typically when you're dealing with that model document there, the IRS will come out and say, hey, you have to update that, which we did have that happen recently here. It's going to be needed to be updated by the end of 2022 there. So that it goes over all the rules, and because of when rules change, we have to make sure those rules are updated to reflect that on the plan agreement there. If the IRA owner does not designate beneficiaries, that plan agreement will also tell you who the default beneficiary is. So in other words, it will say, if no named beneficiaries, this is who the money will go to. So that is something that we get regularly. Who will it go to? They didn't name anyone, or everybody has predeceased them. What do we do? Then it will go to the default in the plan agreement. So what is the default beneficiary in your plan agreement? Does anyone know? And if you use a census forms, you can say we use a census forms. That works too. And then I can tell you what that default is.
Is it the estate?
Are you on a census?
I believe so, yes.
Yes, then
Yeah.
yes. The census forms, you're exactly right, is the estate of that IRA owner if no named beneficiary. So it will default to that IRA owner's estate then. If you're on somebody else's forms, it may vary. Some forms list the spouse as the beneficiary. kind of list it out in an option there of it will go to this person first, then this person, if that's to occur. So this is your traditional IRA plan agreement. Notice that it's divided into different articles. These articles will talk about different information that will apply. Like I said, these are the rules that we're agreeing to. So this is a very technical language going into detail about what is expected of that IRA owner, what is expected of that financial organization moving forward there. Whenever you divide it out into the different articles between Roths and traditional IRAs, the only significant difference is Roths have an extra article here, which is Article 2 for modified adjusted gross income restrictions. Everything else is going to be exactly the same between the two. So whenever you're looking at Article 1, it's going to discuss the contributions. So for a given year, how much money can a financial organization accept in order for it to be applicable, in order for them to follow the rules? So they can't accept more money than this from an IRA owner in order for it to be acceptable. The second one is the non-forfeitability clause. It talks about that the IRA owner's interest is non-forfeitable. They can't give it over to anyone else. It's no one else's money other than the IRA owner's money. You've got the MAGI restrictions there for the Roth in that second article, and that's going to be, it talks about if you're of this income limit, then you can contribute to a Roth IRA. But if you're over this limit, then you can no longer contribute to that Roth IRA. Article 3 or Article 4 for those Roths is going to be the investment restrictions. It lets you know that IRA assets can't be invested in certain things. Not invested in life insurance contracts. It can't be commingled with other property. It also can't be invested in certain collectibles other than very specific, specially minted coins and bullion. So it's very specific, saying IRAs can only be invested in certain things. The next one's going to be the distribution rules. With it, you've got traditional IRA distributions. They must follow certain rules, letting you know when you can take money out, when you can take money out with a penalty, what happens, are you required to take money out, things like that. Reporting responsibilities is the next section. This really follows to a lot to the financial organization because it's telling them what's required to be reported. So again, that's then the IRA owner agreeing to it, and the IRA owner saying, yes, I'm going to give accurate information to where you can report it properly to me. Then the next section we've got is controlling articles. It lets you know that articles 1 through 3 of the plan agreement are controlling and they cannot be modified by other articles. Amendments, that's a financial organization must periodically amend that IRA to make sure that the IRA plan agreements to make sure that they are up to date on the most current law changes. And then the last section there, financial organizations may add other provisions in Article 8 of the form. It does have to be consistent with existing regulations. So in other words, any additional things that they want to do as a financial organization, you can put it in that last article. It would be Article 9 for the Roth IRAs. But it's just saying that's where the customization would come in that you're dealing with moving forward. So that's the plan agreement in a nutshell. It's that contract, okay? The next part we're going to talk about is the disclosure statement. When opening that traditional or Roth IRA, we have to provide an up-to-date disclosure statement. It's going to explain the rules in non-technical language. So in other words, all that mumbo jumbo, that legal mumbo jumbo we find in the plan agreement, what does it actually mean? Let me understand, okay? So by providing that with it, you have to give it copy to the IRA owner, and then you have to keep a copy on file of that disclosure statement that you gave, or a signed statement noting that they did receive that. disclosure statement, and then amend that document as required. So, I mentioned plan agreements are typically only updated when the IRS says, hey, this needs to be updated. Disclosure statements do have to be kept up to date with the current rules and changes that have occurred with law changes. So for example, you're on a census documents. We have already updated our disclosure statement to show those Secure Act changes. While our plan agreement can't be updated until the IRS does that, we have our disclosure statement up to date. So we'll give that non-technical explanation of the rules. Because let's be real, who's going to want to read a lot of mumbo jumbo that's legal or something that's easier to understand? Most people would go more towards the easy to understand section there. Something else important is that the receipt of this disclosure statement begins the revocation period. What is a revocation period? Well, it is a period where the IRA owner can open an IRA and then say, you know what, I decided not to do that. So they would get their full investment back. So if they put in $6,000 and the market crashed in that 7-day period, they still get back their $6,000. Okay, so they have this revocation period time to revoke that from the IRA from receiving that disclosure statement without being assessed any penalties or fees. I'm sorry, go ahead.
How long is that revocation period?
Great question. Yeah, so it has to be at least 7 days from receiving that disclosure statement, at least. Now, there are people that have a longer revocation period with their financial disclosures or disclosure statements, but it has to be at least that 7-day period.
And then is that governed and dictated by the individual organization or by the IRS?
The IRS requires at least a 7-day. From there, the financial organization will decide how long they want to do it for, if they want to change that in the agreement. So it would be in the disclosure statement, whatever amount that is chosen there.
Okay, thank you.
You're welcome. And so that kind of answers our next question there. Based on the sample form, which you find on the next slide, what information is found in that disclosure statement? But I would like one of you to give me that in easy to understand terminology. What is found in our disclosure statement there? So what's going to be the most important thing that you're dealing with is the right to revoke. And that's at the top left-hand corner of the disclosure statement. Note here that it says specifically within 7 days of receipt of the disclosure statement. Okay, that's our IRS Essentials forms here that you're dealing with. So if you're on our Essentials forms, that's going to be your revocation period. But remember, the rest of the disclosure statement is important because it goes over that non-technical language there. The last section here, our F of our PDF, is our financial disclosure. This is not as important as it used to be. Way back whenever they first started these, it was important to kind of know the information on investments, how the money is going to move, how it's going to increase if we were to invest it in certain things. This is still important information. Most financial organizations have it somewhere on their website where people can look at this information. So it's a lot easier to access nowadays than it used to be because we have websites, we have different forms we've printed off, we have things like that that can let the IRA owners know that information about the investment that they are actually starting there. So there's two different types of financial disclosures that you might see. And this financial disclosure is required to be provided to that IRA owner, even though it's not as important as it used to be. It's still required. It's still an IRS required document. And it is required to be given at the time of opening that account. It is never required to amend this amount, even if the investment and rate changes. So we never have to deal with this financial disclosure again. The financial disclosure is not required to be in the IRA owner's file if other documents state that the IRA owner has received that information. So in other words, you have something signed by that IRA owner saying, I received it. This is kind of a small recommendation. Financial disclosures are extremely complicated. And I'm going to be honest, they're really easy to mess up moving forward with them. So let's see, if you have a signed document in your file from the IRA owner saying, yes, they received that, you don't have the proof of what the actual financial disclosure was. So in other words, you don't have the proof of your mess up if something wasn't filled out quite perfectly. So if the IRS were to ever audit the files and they see that you have a financial disclosure filled out improperly, then they'd go, oh my gosh, I have to audit everything because they've been doing this wrong all along. Whereas if they just see that signed copy, well, they provided their financial disclosure, we're good to go. So see, that's why it's one of those things where it might be better in this case. Less is more in this case, in other words, where typically I'm all about the more information, the better. This is one of those cases where less is definitely more. So the first category we're going to talk about is the financial disclosures where growth cannot be projected. If this is the case, this is typically when you're dealing with those self-directed IRAs where it's really not possible to project the amount of earnings that are going to occur. In it, you have to provide the investment options, give that general description of the investments offered through the self-directed IRA program, and the fees. So that general description of the fees that the financial organization may apply to a self-directed IRA. Also the earnings. So a general description of how they're going to compute those earnings, not necessarily the amount that will be earned. And then you're also going to need to include in statements that the growth and value of the IRA is neither guaranteed or projected. And then the last part would be any other information that may aid that IRA owner. So any relationship between a financial organization and an affiliated brokerage firm, or the procedures to request an investment transaction. So that type of information. Now, when growth can be projected, they expect a lot more of us to be very specific in it. And if that is the case, we have certain assumptions that we're going to follow. So in other words, this is not necessarily what is actually going to occur with this IRA owner. We are assuming certain things. This is one thing that has driven me crazy about financial disclosures ever since I started, because I'm like, why are we giving them this information if it's not even necessarily what's going to happen? Because it's a way of giving them a projected assessment of the growth if they were to do certain things. Okay, so if you were to follow this exact formula here, this would be your growth. So the first thing we have to provide will be the IRA value at the end of each of the first 5 years during which the contributions are to be made. So it would increase to this value each year, the first 5 years. We have to note that there. The next one's going to be the account value at age 60, 65, and 70. So if an individual starts at 30, you know that you have to look at 30 years at 30 years after when they started there to note and circle that information too. The contribution is where it gets a little more of an assumption there, because we're going to say that when an individual establishes an IRA with a regular contribution, this is going to be a financial projection based on assumption that every year the IRA owner will make a $1,000 deposit on the first day of each year, regardless of what contribution was actually made. So it's based on $1,000 each year, and that $1,000 has to be each year, the first day of each year made. It would be the same thing as if we were rolling over the money. It just would be based on that $1,000 as a rollover or transfer contribution there. The age used will be the age the IRA owner will attain in that contribution year. So in other words, how old will that IRA owner be on their birthday? What is the oldest age they will be in that year? Whether they are that age or not when they open up, doesn't matter. It's the oldest age they will be that year. And we've got the investment instrument, which that's going to be what type of investment they're doing. Is it a CD? What type of CD? How many, what term, that kind of thing. The term of the certificate is the next section. So that's where it's going to say which exact length of time are we using to do this? Which one did they choose? And then your earnings rate. The earnings rate can be no greater than that which is currently in effect. And the compounding rate is the same. It can be no greater than that which is currently in effect. Then finally, you've got that loss of earnings penalty or fee. And what that does, it tells you what penalty will apply if you're dealing with that section. If you are on our IRA Direct, we actually fill out this simplifier for you. We fill out this financial disclosure with our IRA simplifier. So you insert the information and it's completely filled out for you, so you don't have to worry about it. If not, this is going to be what you're looking at there. It will tell you that information on it. And you'd have to circle the first 5 years, 60, 65, 70, things like that, and fill this out. So this is what your IRA Direct financial disclosure will look like. So slightly different than the previous one we looked at, but that's what's included when you fill out the forms yourself. And here's what our financial disclosure with IRA Direct looks like. Now we are going to do our little running review here prior to taking a break, and then we're going to take a break for a few minutes and make sure everybody's good to go. So first thing, what are the common tax advantages between a traditional and Roth IRA? So traditional and Roth IRAs both have two common tax advantages. What are they? Two common tax advantages.
The tax credit.
Good, tax credit. And what is the other one?
Tax waiver.
Perfect. You're exactly right. It's always tax deferred earnings and a tax credit possibility. What is the advantage for a traditional IRA only?
Tax deduction.
Perfect. Yep. And then what about a Roth IRA only?
The free money.
There you go. I like it. Free money. Exactly. Tax-free earnings possibility. Very good. Now, what are my 3 IRS required documents? And I'm giving it to you easy here, guys. You can give me the initials for it even.
PDF.
Awesome. Plan agreement, disclosure statement, and financial disclosure. Required, remember? And then what additional documentation might be recommended, required for some financial organizations?
With the application.
Very good. Yes, thank you. The application. All right, guys. So we are now in between sections here. Is everybody good with a 10-minute break? Give me a thumbs up if you are. All right. So we are going to do a 10-minute break here. Be back here at, it's 10:35 my time. So be back here at 10:45 and we'll hit the ground running with the next section here. All right, so everybody should be getting back here. You should be seeing my IRA Essentials screen here. It kind of started me back at square one here, so let me get to the page we're actually on. If you have any questions, now's a great time to ask questions before we get into the IRA funding section. I'm kind of giving you guys a little time for the stragglers to get back to here while I do this real quick. But like I said, we're about to get into the IRA funding section, which is all about how people put money into their IRAs. I have seen a couple questions come through, and if you're looking to talk to Stephanie, actually the best person to message on that chat is going to be the MI Bankers, Michigan Bankers one, not the Stephanie one, because that's the one I'm actually presenting on. So I can't answer some of the questions for her there. So it'd be better to send it directly to her on that. I am able to see my chat feature now. I think as long as everybody can see the screens I'm quickly going through here, you should be able to chat me now as well if you have any questions. So everybody good to go? Give me a thumbs up if you are. All right, not seeing any thumbs up. Okay, there we go. I was going to say, can people hear me and see my IRA funding slide then? Okay. So we are going to go ahead and get started here with the IRA funding section. So fun times here ahead. We've got a bunch to talk about in this section, and then we'll go to lunch, and then we've got a couple more sections to go from there. This section, we're going to compare and contrast traditional and Roth IRA eligibility requirements. So in other words, what are you required to meet, or what types of things are you required to do in order to be eligible to make a contribution to an IRA for both a traditional and a Roth? Are there differences? What are those differences and how do they apply? We're also going to talk about that regular contribution limit and what exactly, I love that. Some people can't react, and that's fine. If you just put in the chat feature that you're able, then you're good to go. Okay, so we're seeing a different slide thing than what I want you guys to be able to see, I guess. So you're not seeing the big learning objective slide. Are you seeing the black screen?
I think you just need to hit full screen on your presentation software.
Let's see here. See if it'll let me.
Or if there's a presentation mode.
Yeah, there we go. Display settings, swap. Are you able to see it now? There we go. You should be seeing the full screen now, correct?
Not yet. We still see your next slide and no notes, your presentation controls.
Oh, goodness gracious. 1 second here. Did that work now?
Yes.
Okay,
That was it.
good. Okay, you don't see my chat feature, do you? Just the actual thing, right?
Nope, just the full screen slide is all we see.
Perfect. Okay. All right. Sounds good. Okay. So now we're going to talk about, like I said, the regular contribution limit and exactly what we're dealing with there. So that means, in other words, how much can we contribute to an IRA? How much money can we put in each year as an IRA owner? Then we're going to talk about the regular contribution deadline. So in other words, if I'm putting money into my IRA, when must I have it in to count for a specific year? Then we're going to talk about the rules for prior year contributions. What extra must we do in order for it to count for a prior year? And finally, we're going to talk about that regular contribution reporting deadlines. So as a financial organization, what is expected of us to make sure that you are able to properly report and give the information that the IRS needs on that IRA moving forward. So the first part we're going to talk about is that traditional IRA and Roth IRA contribution eligibility. For that, the one common theme across the board is going to be everyone is required to have eligible compensation. What does that mean? It means that you must, in order to contribute to an IRA, be working, be putting some money into the IRA because you have earned compensation, you have worked as a waitress, worked as a banker, worked as something. You must have some type of money you are currently making in that year you are wanting to contribute to. Remember, this is to contribute to an IRA. Anyone is eligible to open an IRA at a financial organization, but in order to put money into it, new money, remember, new money, you are required to meet certain eligibility criteria, and that can dictate how much you can actually put in. So we're only eligible to put in the maximum contribution amount, or if it's lesser, the amount of eligible compensation we have for that specific year. So as you can probably figure, there are tons of sources of compensation where money can come from, how it comes in, how you get money, how you make money. There are a crazy ton of ways, but eligible compensation is very specific. You're required to make a certain kind of compensation in order for it to count. Whenever you look at the sources of income here on this slide, you've got two different categories that it will fall into: eligible compensation versus not eligible compensation. With that, I want you to kind of take a look at all of the things that fall under eligible compensation. Do you see something that is in common? And you can either verbally say this or type it in for me. Both of those work. So do you see something that all of these types of compensation have in common? So the way I like to think of it here is all of these types of compensations you see under eligible compensation are sweat dollars, or money we are actively working for, money I have to put effort in to receive. You've got your wages, so that's what you receive, your hourly wage, the amount of money you receive for doing your job, your day-to-day job. Salary, same thing, you get a certain amount every year that you are told you are going to receive as long as you work those days. Tips, that's a waitress, they're out at or driver, anyone like that, they're doing this and receiving a little bit of extra income because they did a great job. Same with bonuses. Commissions, you sell a house, you get a commission off of selling that house. Professional fees, you're going to see people like doctors and lawyers with these professional fees. They request a certain amount of money in order to do whatever they are doing for you. Combat pay is kind of a different one, and I always like to talk a little bit about this one in detail. My husband is actually deployed currently, and so this one kind of hits close to home, and it's one of those things that kind of is interesting to me. Most of these wages we've gotten, not wages, compensation we've gone through so far, it's all you consider taxable income. It's money that you're going to be taxed on in that year. Combat pay is different. It actually is something that they are working and they are receiving, but because that they are in they're deployed or they're in this special zone where it's considered not safe, their benefit is they're not going to be taxed on that income for that time period. So my husband, he's actually been deployed for 6 months now, and he's finally on his way home, guys, and I'm super excited. But he's been gone for that time period. That entire time period, he wasn't taxed on that income, but we can still use it as eligible compensation when it comes to retirement time. So it can count towards that. Certain payments to graduate students, this counts. Let me give an example on that one. Whenever I was getting my master's, I told you, as a master's of fine arts in creative writing, and I worked as an editor there for that literary magazine. So they'd send me certain articles and stories, and I'd say, yes, it should go in the magazine. No, it shouldn't. Here are my edits to this, things like that. I would receive a certain stipend every year for that. And it's not that I actually received the money in hand, like most payments that you do, but it went towards my tuition. And so instead of owing $5,000 in tuition, I only owed $4,000, that kind of thing. Okay, so like it took it away from my tuition. This could technically be considered eligible compensation. I don't know many graduate students that are in that position to be able to do that, but thankfully there are some that can make a contribution to their IRA. I know that money was definitely used towards my tuition whenever I was there, but other people are in different situations and they can now use that. So that's one of the things. Oh, go ahead.
Is that stipend then taxable? Like if it was $1,000 stipend, do you owe taxes technically on that portion of the stipend?
I do not remember being taxed on that portion, but that was way too many years ago for me on that. So I think it's one of those things that it literally, like, it just makes your tuition less, is almost how it works. Good question. But that would be a good question too, that if they were dealing with it, they would want to talk to their competent tax advisor to make sure they handled that tax side of things correctly. Yeah, very good. The last one is going to be the difficulty of care payments. And this is something that's really for just that small niche, individuals. Most people that are receiving those might have other types of income. And this is also a non-taxable money that they are receiving, but it would allow them to have IRA contributions based upon this non-taxable information, this non-taxable money that they're receiving. Typically, it's a type of qualified foster care payment. So why I say most people might have another source of income is this is only just something that they use strictly to take care of their foster child. They probably are working elsewhere. It's not their sole source of income, but it does allow for people to do that. Why are all these different types important? A lot of people forget that it's not just salaries and wages that can be used. There are other things that can be used as well. I like to give an example. We talked about there are 4 different legs people generally draw from for retirement. When you're talking about the eligible compensation, you've got 4 IRAs. A lot of people will also draw from their qualified retirement plans. They've got personal savings, things like that. A lot of people nowadays are working later in their life. I actually just saw an article on LinkedIn last night that said why the baby boomers are now doing what they consider partial retirement. So most of them are continuing to work part-time or finding another type of job part-time to continue moving forward. It's just we don't know where the world's going to be, and so a lot of people find this extra source of income as beneficial. So whenever I was back in an area, Missouri, prior to working here at Essentials, I worked as a copy editor, and the place I worked was just down the road from a Honda dealership. I had a little Honda Civic at that point in time, and I was able to take my Honda to the dealership to get the oil changed, and then they would drive me in like a shuttle van back to where I worked, and then come pick me up to pick up my car later. Well, me being the type of person I am, as you guys can probably tell already, is I don't like silence. I love having to talk to somebody. I love kind of filling the void and making sure people are, entertained, is I guess a way to think of. So I would always talk to the drivers as we went. There was one day in particular, I remember I was talking to this older gentleman, and I asked him how long he'd been working for Honda, and he said, oh, several years now. And I asked him what made him want to get into it. He goes, well, I'm going to be really honest with you. He's like, I worked as a lawyer for years and years and years. So there you go, either that professional fees or maybe a salary, depending upon what he worked for. So he had that set source of income. Said I worked for years and years and years like that and made a great retirement, have enough money to retire and everything like that. He goes, but suddenly once I retired, I was at home all the time. And my wife, who had been a stay-at-home mom and who'd worked from the house for years and years and years, suddenly I was stepping on her toes everywhere I went. You know, she's used to being able to do this at a certain time, and I'm in her way. She's used to being able to cook her lunch, and again, I'm in her way doing something. He goes, so finally my wife told me one day, honey, for my sanity, you've got to find something to do during the day. You got to go back to work. And he's like, I think it was a good decision, best decision for my marriage, because I went back to work and we were both a lot happier that I wasn't there full time, all the time with her. So even though this isn't a full-time job, he does have those wages that he was making, or tips too, possibly for being that shuttle driver. So he could still continue contributing to that IRA based on having that eligible compensation. Okay. You look at the not eligible compensation side. Again, think of it as not sweat dollars, you know, that money that you're just receiving passively. So you've got eligible compensation being that active, you're working actively for it. Not eligible compensation is that money that you just kind of get because you're doing whatever you're doing. So you got the taxable alimony. That one I love hearing the arguments on, because people are argue constantly, well, I'm working to not want to, you know, I'm working to deal with my ex-husband, so that should be considered eligible compensation. It is not. Interest, it's that money that earns because you have money sitting in an account and it just receives that extra money for it. Royalties is one that can be different. It can count as it possibly, but it depends upon what exactly you're doing. So for example, I'm a Harry Potter nerd here. So J.K. Rowling, she is currently still an author, still writing. I'm sure she's still receiving royalties on all of the Harry Potter books. Because she's receiving royalties on that and she's actively working, this would be something she could talk to her competent tax advisor about to see if those royalties could be counted as eligible compensation. Dividends, again, something just earned because the money is in something, just passively accruing. Rental income tends to be one that people want to argue a lot too, because you have to work to keep up a rental house. You have to make sure as a landlord you have certain things that are accomplished. But the actual rental income is just passively received. So if they want to receive money for the work that they do and count it as eligible compensation, they might have to work out a different way with their competent tax advisor to use that. Unemployment compensation, well, that says it right there. You're unemployed, you're receiving compensation for that. Disability pay, people might want to say, well, I'm receiving it because I can no longer work and I receive this benefit from working because of it. It has to be in the current year that you are working that you can do that. Child support is not counted. Separation and early retirement is not counted. You've got the aid to families with dependent children and temporary aid for needy families, does not count, as well as your Social Security income, that does not count as well. So it has to be money you are actively working to receive there. Traditional IRA contribution eligibility. So we talked about eligible compensation is for both traditional and Roth IRAs. That is the only eligibility criteria for a traditional IRA, is eligible compensation. You used to have an additional one where you had to be under the age of 70 and a half, or you couldn't obtain age 70 and a half in the year you're making the contribution for. And that was 2019 and earlier years. Since the passing of the Secure Act, we can make those contributions at any age as long as we're making eligible compensation. So that Honda driver we talked about, even though he was in his 80s, he could now make a contribution using that money he's making. If he doesn't need it, he can put it back into a traditional IRA. So what you do see with this is you might see people taking distributions and making contributions at the same time. So it is interesting that that now happens with those traditional IRAs for that contribution eligibility. Roth IRA contribution eligibility, that you're going to deal with the eligible compensation, which the IRA owner must have eligible compensation, as we talked about, for either type, and they have to be in a certain income limit. That income limit, you should be able to find in your guidebook there. I think it should be on page 28 of your guidebook, and it goes through the different limits for contribution eligibility. What it boils down to is that you have to fall into a certain range that you are working with here. So whenever you look at this, you should see that a filing status that you have to abide by, and that filing status will tell you whether single, married filing jointly, married filing separately. If you are eligible for a full contribution, so that means a full contribution amount, we can only make up to $125,000 for 2021. Married and filing jointly, they give you an increased contribution, or not contribution amount, but increased compensation amount there to be able to contribute to, because think about it, you're now accounting for 2 people. So they give you up to $198,000. Now you'd be eligible for a partial contribution if you fall between these ranges 125 to 140 and 198 to 208. If we fall in that range there, we get a partial contribution. There is a formula to calculate this partial contribution. It's in the instructions for IRS Form 8606. This is not your responsibility as a financial organization. It is the responsibility of the individual to be able to do that. So that is their responsibility there moving forward. If we make over 140,000 or over 208,000 for a Roth, we are ineligible to make a contribution to that. This bottom section, and yes, it is only till 10,000 on either case. It's married and filing separately. Why is it so low? The only thing I can really think of is that what you're dealing with is the IRS doesn't really want you to do married and filing separately. There's too many benefits to being married and filing jointly. So they kind of say, well, if you're doing that, then you're up to no good. I don't believe that you're doing it for kosher reasons there. So they only allow you to do it for this amount. So why is there these limits on Roth IRA contributions? Well, remember I told you you can get free money, you can have interest earned on this and you not pay the taxes on it. I guess the IRS kind of says, hey, you're making enough money anyways. You don't need free money. You can pay the taxes on the money. So they require that you have this, not be able to make a Roth contribution if you are above that certain threshold there on what you're dealing with. So you should be, sorry, the 2022 screen is what you should be seeing now, correct? Everybody sees 2022 MAGI limits for Roth.
Yes.
Good, thank you. The computer keeps doing funny things here, so I'm trying to make sure I'm always on the right page. So with this one, notice that the amounts did go up. It was 125, it's now 129 for single, and it was 198, it's now 204 for married filing jointly. That ineligible amount, it did go up as well too, so from 140 to 144, 214 here. So those are the different limits for that compensation, for that modified adjusted gross income, whenever we're considering it for Roth IRA contributions. Again, it is not your responsibility to know the amount they are eligible to contribute. It is the IRA owner's responsibility. It's their responsibility to talk to a competent tax advisor to make sure they're eligible to contribute the amount that they want to contribute. spousal contributions here. I'm going to kind of date myself a little bit. So I like to think of spousal contributions as the Brady Bunch contribution. Okay. We all know the Brady Bunch from back in the day. You had Mike, who was an architect and go to work every day and work, and Carol, his wife, stayed at home and took care of the family and not the house. I'm not really sure, but she did, you know, she took care of the family, and then Alice took care of the house. But whatever the case, Carol was at home. She was not out working day to day there. So because of this, they developed this law that allows individuals who file a joint federal income tax return as married individuals to be able to contribute on behalf of the other individual who is not working. So in this case, Mike would be able to contribute, or Carol would be able to contribute based upon Mike's compensation. So technically they could contribute to both Carol's IRA and Mike's IRA, as long as they were meeting those other eligibility requirements. As we know now, traditionals, they only require you have that eligible compensation, and Mike's would be satisfactory for Carol's for these purposes of making that contribution. Roth's, he'd still have to have that fall into that correct range then for making the contribution then for Carol. It's important to note that each spouse would be responsible to contributing this amount to their own IRA. They couldn't contribute it all to Mike's IRA. So in the case of each one being a $6,000 contribution, they couldn't contribute $12,000 to Mike's IRA. They'd have to contribute $6,000 to Carol's and $6,000 to Mike's. We'll go back to my Honda driver now. You would also have to have enough eligible compensation to cover those contributions. So if he only made $7,000 and he wanted to make a $7,000 contribution to his because he's over that catch-up contribution age, and a $6,000 to his wife who's much younger, he couldn't do that because he only had $7,000 worth of compensation. So you have to have the compensation to support the extra contribution there that he's making. Okay. So remember, spousal contributions is that Brady Bunch rule there that we can make contributions to our IRA as long as our spouse has that eligible compensation to support it. And we're filing jointly there.
This may
And
be
go ahead.
question. You don't have to contribute equally to those, would you? Like, for instance, you know, Mike could do 5,000 and only do 1,000 to Carol. It doesn't need to be even between the two.
Correct. Yep, you're exactly right. And even if Mike didn't contribute any to his own, he could still always contribute to Carol's. Yeah, you're exactly right. And so, like I said, on that one, Mike doesn't even have to contribute to his own if he wants to contribute to Carol's. Maybe Mike has a retirement plan that he's doing at his architecture firm, and he's contributing all his money there. So he says, you know, I just want to do something for Carol still too. So that's fine too.
You can still only do 6,000 to Carol.
Depending upon age, yeah. Great question. So here's a couple examples then. Lauren, age 50, has eligible compensation of $140,000. Fred, age 48, is currently unemployed with no source of eligible compensation. Lauren and Fred are married. Their joint MAGI for year 2022 is $150,000. Great time for you to flip back and look at those MAGI limits just to make sure you're on board with how it works. So their joint MAGI is $150,000. They're married and filing jointly. So which category they'd fall into, follow it from there. So Lauren is eligible to contribute to which type of IRA and why? Which type of IRA can Lauren contribute to?
Both.
Correct. Yes. And you guys can chat in the answer too if you're not as comfortable with vocally saying it, but you're exactly right. She can contribute to traditional because the only requirement is eligible compensation for a traditional. And she has it, right? What about a Roth? She can, because she has that eligible compensation and she falls below the MAGI limit there that we're dealing with. Of she can do up to 198 to get that full contribution there. Now, oh, sorry, 204 then for 2022. Fred, can he contribute to an IRA, and which type and why?
So Fred can't personally, but his spouse can on his behalf.
Correct. So then I like the way you worded that. So then that brings up another point here. Did anyone else lose video? Someone lost video on my side. Everybody else good there?
So good.
Okay. All right. So he can do a traditional and a Roth IRA based upon Lauren's compensation, right? Does Lauren have to physically put the money in for him? No, Fred could actually do it. Fred could be the one to bring in the money. It just has to be, so say Fred only has rental income like we talked about of his own, and he's not even technically even using Lauren's dollars, but his income is considered not eligible, right? So he's physically putting in his own money, but according to the IRS, we're going to count it as Lauren's money. Does that make sense?
But only because they're filing jointly.
Correct. Exactly correct. Yes. Because they're filing jointly. Think about it this way. When you look at that 1040 at the end of the year, there's a dollar amount down at the bottom between the two of you when you file jointly. So that's all they see is they see that, hey, there's this, he's got the eligible compensation for it because of Lauren.
So if they were married filing separately, then he would not be able to contribute.
Correct. Yep. Mm-hmm. You're exactly correct. All right. So that's spousal contributions. Now that we've talked about spousal contributions, let's talk about that actual contribution limit there. So if you meet the requirements for that eligible if you meet the requirements of eligible compensation for a traditional IRA, then we have to have at least eligible compensation up to the amount we want to contribute. The maximum amount we can contribute, no matter how much money we make, is $6,000 to a traditional IRA. That does not mean the entire amount will be deductible. It just means that that is the amount we can actually put into the IRA. So we can still contribute even though the whole amount might not be deductible based upon that chart on IRA deductions. If we are 50 years or older, so in the age we attain 50 and older, we can contribute an extra $1,000 to either a traditional or a Roth IRA. Okay, now the Roth IRA amount is always going to be figured out based upon where you fall on that MAGI limit. You may not be able to contribute the full $6,000 or $7,000, depending upon age there based upon where you fall. And like I said, you'd use that 8606 in order to help you figure out where you fall on that MAGI limit and the amount that you can contribute there. And when I say you, I use that term very loosely. It would be the IRA owner doing that, not you. So the IRA owner would be the one using that form to figure out how much they can contribute. In 2022, that amount did not change. It's still $6,000 and a $1,000 catch-up. The $6,000 amount does increase based upon cost of living. It was $5,500 for years and years. It did go up to $6,000 recently here. The catch-up contribution is actually a tax law thing. So it would need to have a new tax law put into effect in order for that to change, that amount to change. Until that point in time, it will be subject to that $1,000 catch-up. Now, I mentioned that they can be age 50 or older, but one question that comes up a lot is, What if they haven't turned 50 yet and they want to make that extra $1,000 contribution? As long as they turn it by December 31st of the year they're making the contribution for, then they can make that contribution. Okay. Remember, this is an aggregate contribution amount. What does that mean exactly? That means, say I have a traditional and a Roth IRA. I can't contribute $6,000 to my traditional and $6,000 to my Roth. No, it's $6,000 per IRA owner. So they're subject to that amount between all of their IRAs. Well, say they contribute $6,000 to a financial organization over there and $6,000 to your financial organization. They can't do that. Only one of those 6,000 is going to be eligible there. So it's, and that's not your responsibility to know, it's their responsibility to make sure, but it is important to note that between all of their IRAs, per IRA owner, per tax identification number, they're only allowed these contribution amounts total. So not per type, not per account, nothing like that. It is per tax identification number. If they do not make enough compensation to support the full amount, so my Honda driver, maybe he only made $3,000 that year, he can only make $3,000 contribution. So they have to have at least the amount of compensation that they want to make in a contribution. Okay.
What about, let's say Honda driver makes 3,000 in 2021 and then makes 20,000 in 2022. Can he then, after the calendar year in January, go back and catch up his $3,000 contribution up to 6,000 because he had now the new income limit?
Great question. Great question. So no, his 2021 income was 3,000. So he's stuck at 3,000 for that year. But 2022, he could make the full contribution of even 7,000 then if he's over that age 50, like we talked about. So that's a great question. It does have to be the year for which you're making the contribution. So even if he waits to make his contribution until that contribution deadline there, which actually falls in 2022, it's still, he only made 3,000 in compensation for 2021. Great question. All right, so here is an example. Lauren, age 50, remember, has that eligible compensation of $140,000. Fred, age 48, is currently unemployed with no source of eligible compensation. Fred and Lauren are married. Their joint MAGI for tax year 2022 is $150,000. So how much can Lauren contribute for 2022 and why?
Can you go back to the previous slide real quick?
Go back to the other slide.
Yeah.
So how much can Lauren contribute for 2022 and why?
So Lauren can do 7,000 and then she could contribute on Fred's behalf another 6,000. Right?
Awesome. Yep, so she can do 7,000 because she's over 50 or 50 and older there. So she gets that extra 1,000. And you actually answered the next slide too. So Fred can contribute then only 6,000. Why doesn't he get the extra 1,000? Because he's not 50 himself. So this is a point that comes up very often too. So because we are basing it on Fred's tax identification number, he actually has to meet that catch-up amount age in order for it to be contributed into him. So what a lot of people want to do is they say, well, Lauren's eligible for the catch-up and we're doing it based upon her compensation. So it goes across the board, right? No, remember, it is individual specific there. So that age has to be eligible for it. So if Lauren, let's say Lauren, it was the reverse order and Lauren was 48 and Fred was 50. it would be the reverse amounts there as well. So Lauren could only contribute 6,000 and we can contribute to Fred for 7,000, even though her compensation was what got them there.
But
Does
if,
that make sense?
but if Fred was 49, but turning 50 within that tax year, then he could do the catch up.
Exactly. As long as it's by December 31st of the year they're making the contribution for. Very good. So now we've talked about the contribution amount. Let's talk about that contribution deadline then. Whenever you have individuals who are wanting to make a contribution, I like to say between January 1st and April 15th of a year, you always need to ask them what tax year it is for. Why? Because there are different things that apply if you're doing a prior year contribution. So what the IRS has allowed for is they say, you know what, in the entire year that you want to make a contribution. So in 2021, you get from January 1st, 2021, all the way through December 31st, 2021 to make a contribution for that year, obviously, because it's in that year, right? But we're going to give you an extra few months here into 2022, knowing some people might not know how much they're going to make that year until later, or they may not have the funds yet, and so they want to make that contribution at a later time period. So they actually give us a few months all the way till 4/15 most of the time, generally speaking, of the year, in order to make that contribution for the previous year. Now, they do say there's additional things they want you to do if you're making that prior year contribution. They want to make sure that you note it, that it is going to be a prior year contribution. If April 15th falls on a Saturday, Sunday, or legal holiday like it does this year, then they get until that next business day. So for most people, I think this year it's going to be that April 17th, or maybe it's 18th this year, but they are going to get until that time period. I think it's April 18th this year, actually, is what I want to say. Yeah, 18th. And then some people, depending upon where they're located, might actually get until April 19th this year, because another federal, that holiday will fall for them, so they don't get to do it. So it is April 18th this year, even though the 15th is technically on a Friday. It's Emancipation Day, so they're not going to be having it on that day. Now, if we have that, it is for their contribution. It is still that due date, right? If they get an extension on their filing of their federal income taxes, they do not get an extension on this contribution. The only way an extension can possibly happen is if the president declares, you know, we are extending this time period. And, you know, that did happen recently. Before that, it hadn't happened in a long time, but it did happen in COVID year. They extended that contribution deadline. But for the most part, this is generally going to be your deadline that you are speaking with there, that you're working with there. So you always want to ask when they come in, is it for a prior year or a current year? Why? Because prior year contributions must be made in writing, and they are irrevocable. So we can't later come back in and say, I wanted it to count for a current year, I changed my mind. No, it's a prior year because you wrote in writing that it was a prior year contribution. A lot of people use our contribution form or another type of contribution form. And an example on our contribution form, it actually gives you the option to choose what year it's for. I recommend on this area to actually have that IRA owner initial next to that date that they choose, if they choose a year, next to that year, because think of it this way, a lot of times at a financial organization, you may fill out most of the information for them. And if they come back in and say, hey, you filled that out, I had nothing to do with filling out the year, how do you prove it? Well, if you have their initials next to it, it kind of helps prove that and keep that, and you know, keep that safe there. I mean, you can really note in writing any way you want. There's no set way required by the IRS on this. just know that it is irrevocable. So if they make it a prior year contribution, it's a prior year contribution no matter what, no changing to current. The same though is true for a current. They can't later change it to a prior year. Because why? They didn't note it in writing at the time of making that contribution. I see a lot of people ask about checks. Can the check just have in the note process that it's a prior year contribution and what year it's for? That is totally acceptable as well. So the other thing you might hear about is people mailing in their contribution checks. As long as it's timely postmarked, so postmarked by that deadline, and it includes that written direction saying it's for a prior year contribution, then they can accept that contribution. So say that they mailed that check on April 14th, it's postmarked April 14th, but you didn't receive it till April 22nd for some reason or another. It was postmarked by the deadline and it included that written instruction. Therefore, you can use that to count for that year. Another thing, go ahead.
That the contributions are irrevocable, does that mean it's exempt from that revocable 7-day window or whatever, like with when you're establishing the account? Is that exclusive to the establishment of the account, not contributions?
Correct. So it's exclusive to a contribution made at the establishment of the account. So if somebody made, they established their account and then made the contribution as a prior year contribution, yes, they could still revoke it as long as it's still in that time period. But a regular everyday person who's already been contributing to their IRA can't revoke it in the sense of they can't change it to a current year contribution. You know, they can't change the year is more what that's specific to. Good question. Direct deposits, something a lot of people don't think about is those are automatically going to be made for a current year contribution. Unless that financial organization receives instruction, written instruction prior to that current year direct deposit. So you'd have to have something sent you, hey, I'm about to have a direct deposit that's going to go in there. I want it to count to a previous year. Then you could change it to that prior year contribution. But that's typically, some financial organizations don't even allow for that because current year contributions are just how it's automatically set up in the system there. So here is our contribution form. Part 3 is where they would fill out the contribution amount and the date that it's being done. And then you choose that it's a regular contribution. This would also include spousal contributions here, if you're checking that. And then the contribution for tax year, they write the tax year here. And as I said, it'd be great to have them initial out to the side, noting that they are agreeing it is for that tax year. That way they are fully on board with noting what year it is for there. So let's do a couple questions here. I'm going to give you a couple minutes. And it's 11:33 on my side. So at 11:35, we're going to go over these answers. And I want to see more responses on chat or talking too. So if you guys make sure you get together what your answers are going to be. I want to make sure you're all still awake. Okay, come on, guys.
So Merle could do, as long as he has earned income, you know, of 7,000 each year, he could make 7,000 for 2021 and 7,000 for 2022, correct?
Yes, so for what year can he make the contribution and why? If he is, today's February 7th, 2022, and Burl, age 51, would like to make a contribution to his IRA, he can elect either tax year 2021 or 2022 between January 1st and that tax return deadline. Now, he does have to, like you said, have the compensation to support that contribution whenever he elects that for the year. Good. Now, the next one, does Burl need to give the financial organization written instruction for the contribution? Or another way to word it is, when would he need to give written instruction for the contribution?
Written instruction for previous year.
Very good. Burl only has to provide that written instruction if it's made for a prior year contribution. Does that mean we're suggesting contribution forms aren't a requirement? Well, they technically aren't a requirement from the IRS. Highly recommended because it keeps track of those contributions going in. But even if you don't use a contribution form, he still has to note in writing if he wants to make it a prior year contribution. If Burl mails in the contribution check postmarked April 14th, 2022, and you receive it on April 21st, 2022, can you still apply it to tax year 2021?
Yes, with written instruction because it's
Very
posted.
good. Yep. Yes, if accompanied by that written direction. Good job. If Burl receives an extension to file his 2021 federal income tax return, does this extend his deadline to make a regular contribution for tax year 2021?
Nope.
Nope.
Very good. It's like we have a consensus here, everyone. No, you're exactly right. It does not give that extension for 2021. Now, here is a form that you want to become your best friend because it's something that is very much a requirement by the IRS. This is our form 5498. It is used to report those IRA contributions. So the information for our IRA contributions. It reports to the IRA owners as well as the IRS. Every year it's going to be used for those reportable contributions that are occurring. So this is a 2021 one. Technically, they won't receive it until May 31st of 2022. That's the deadline for it. But that's when the IRS is going to receive that information there. So, but it is a 2021 form that reports all 2021 contributions. So by me saying that, why do you think we have a May 31st deadline there if it's 2021 form?
To give you
Any
plenty
ideas?
to account for those previous year transactions.
Beautiful. Yes. So we have an April 15th deadline for those prior year contributions. We still have to be able to report them for 2021. So that is very important to note. So this is due by May 31st to the IRS. And we have to include this information. The stuff that is required is going to be on, we're about to talk through here on it. Box 1 is where you're going to put those IRA contributions for traditional IRAs made in the current year or as a prior year contribution in 2022. So in other words, I would make any contribution I put into my traditional IRA in 2021 up until that deadline in 2022 that I noted was a prior year contribution. All of that would be in box 1. Example, I did 4,000 in 2021, and then I did 2,000 as an extra prior year contribution right there at the beginning of 2022. My total amount there in box 1 would be $6,000 there. We would note that entire amount there, not just the amount that was actually physically made in 2021. In box 10 is where we put the Roth contributions. So I told you I'm a fan of Roth IRAs. So I've got a way to help you kind of remember that, okay? So, and yes, it's corny, and I will give you several corny things as we go throughout this moving forward. But remember, Roth IRAs are awesome. So you put both hands in the air. Yay, Roths are awesome. So you raise a roof, Roth IRA. Yes, I dated myself. I know, it's okay. But Roth IRAs go in box 10 because they're so awesome. We can raise the roof with Roth IRAs, all right? there, box 10. So any prior year and current year Roth IRA contributions will be in that box. You will never see a box 1 and a box 10 filled out on the same form. It won't happen. It can't happen. Why? Because we would have a separate PDF for each type. I would have to fill out a different plan agreement to have a Roth IRA than I did for my traditional IRA. Therefore, we have 2 separate accounts and we have to report them as such on the 5498. So I would have a Roth IRA 5498 and a traditional IRA 5498. Okay. Box 5 will be that December 31st balance of that IRA, also known as the fair market value of the account. It would go in box 5 there. And then you're going to mark the appropriate box here on box 7. Is it an IRA? Is it a simple, a Roth IRA? What type of account is it that we are dealing with for this contribution? So those are 5498s. Remember, due to the IRS by May 31st there, okay? Copy does go to that IRA owner too. The account statement is to the IRA owner if a reportable contribution is made. So you have to send an account statement to an IRA owner who has made a contribution for the previous tax year. It can be in any written format. It is also due to be sent to the IRA owner by May 31st. This is typically what some people might use, that 5498 we just talked about that goes to the IRA, to the IRS. They might just send this as the account statement as well. So it could work on that account statement. If they don't use that 5498, they do need to note that it is being sent to the IRS. That information is being sent to the IRS. It is also due May 31st to those IRA owners, okay? You do not need to submit an account statement itself to the IRS. So if you have a separate account statement, you don't need to do that and the 5498 to the IRS. The 5498 satisfies that account statement there moving forward. The fair market value statement, it must notify that IRA owner of their fair market value. So their December 31st value, that prior year's December 31st value. The fair market value can be in any written format, and it's due to the IRA owners or beneficiary by January 31st. You are not required to send this to the IRS either. Now, what you see a lot is some financial organizations will provide a 5498 actually in January and a 5498 again in May there to satisfy the fair market value statement. So what happens is, you know, they provide the 5498, which has the fair market value on it in January, to let them know that information to the IRA owner. And then later they'll have to revise that though, because if there were any prior year contributions, they would have to update the information at that later time period. So they would still need to make sure that information is updated according to what they're working with from there. Are there any questions on those different types of statements requirements? All right, so now we've got our running review here that we're going to do on funding those contributions. Our regular contributions, what is the eligibility criteria between both traditional and Roth IRAs? What are we required to have to be able to contribute to a traditional or Roth IRA?
Income.
Very good. That earned income or eligible compensation. Make sure it is that eligible compensation though. Now, what is the extra piece of criteria for a traditional IRA? Trick question. There isn't one anymore. There's no longer any other criteria for that. There used to be, and we could not contribute it in the year we turned 70 and a half or older. Now we can contribute at any age as long as we have eligible compensation. What is the extra eligibility criteria for a Roth IRA?
depending on your income limit. And if you're married, filing jointly, single, or married filed separately, and
Very
age.
good. Also known as MAGI too. So income limit is what you're dealing with, but it's dependent upon your MAGI income limit. Very good. Now, the next part here is our annual limit. This is 2021 and 2022. What is our annual contribution limit?
6 plus 1.
That'd be 6,000 plus the 1,000 if you're 50 plus 15.
Perfect. Yep. So we've got an annual limit of 6,000 plus a catch-up limit of $8,000. Good job, guys. And then what is our contribution deadline generally?
April 15th.
Right. The tax return deadline, generally April 15th. This does vary according to when those holidays are or weekends fall into account. Now we're going to talk about those reporting deadlines here. When is our fair market value statement to the IRA owner due? Remember, this is a statement that tells them what that December 31st value is.
January 31st.
Yep.
Just
Good. The 5498 to the IRS, when is this due?
May 31st.
Very good. And then the account statement to the IRA owner. Account statement to the IRA owner. So remember the 5498 is due May 31st, but that's to the IRS. What goes to the IRA owner to let them know the same information?
January 31st also.
That's the fair market value. This one is May 31st. So think of it that May 31st, you have two things that have to go out. It's pretty much the same thing going out just to two different people. Okay. All right. Any questions on what we have gone over so far?
None here.
Nope, not here in Saginaw.
Okay. We can do an hour, 45-minute lunch. What does everybody want to do? Give me your input on how long you want to go for lunch. Hour?
Hour, yeah.
Okay. All right. I'm getting a lot of hours. So let's do the hour lunch then. So it looks like a little before 1 then is when you're going to be back. So it's 11:50, almost 11:50 now. We'll say 12:50 when we're going to head back. Okay.
Sounds good. Thank you.
Thanks, guys. All right, everyone, we're going to get started here. You should be seeing my IRA distribution screen. Welcome back, everyone. Right now, I'm going to give you all a few minutes. Go ahead and give me a thumbs up, a chat in, anything like that, letting me know you're present. That way I can kind of get an idea what's going to go on. But what we're going to do real quick here is a little bit of an exercise before we get started. So what I want you to think about is when you picture retirement, when you picture your retirement, what do you see for yourself? What do you want to be able to do in retirement? And go ahead and chat that in or talk over this, verbalize it, whatever you want to do. I'll tell you what mine is. When I want to retire, when I retire, I want to have the funds to be able to travel and spend time with family. So what about you guys?
Pay bills and not have to worry about it.
There you go. Good one. Very good.
We also said travel.
Travel.
Not have to drive for Honda.
Drive for Honda.
Plus I want.
Exactly. Spoil grandbabies. That's a good one. Not work. That's another one. Very good. So really, in general, everybody just wants to be able to enjoy that retirement time, right? We want to not be focused on what we do on the everyday life right now, where it's, work. Do those things to make sure we can pay the bills, like you guys mentioned, to make sure we can take care of our family. It'd be nice to throw in a little something fun in there, right? Yeah, someone else said funds to live comfortably and travel, have fun. Yeah. We worked all our lives. We want to be able to enjoy the last few years, I hope it's more than the last few, but the last years of our life without having to work and do things like that. Well, IRAs are imperative. They are very much a requirement. Any type of retirement savings is a requirement in order to be able to live without working, right? We have to have something that funds that travel, that gives us money to spoil those grandbabies. Now, if you're like my mom loves finding little things every time she goes to Walmart to get my daughter. And I'm like, you don't have to get it every single time. We have to have the funds to be able to do it, so those are important things. This section here is going to talk about distributions. It's going to talk about getting money out of our IRAs in order to spend it on those things we want to do, or whatever that case may be. But the important thing is, when are we required to take those distributions? How does it work? We're going to talk about federal income tax withholding requirements. In other words, how does the government get our money? What portion of it they get, and how we work that out via the distribution process. We're next going to talk about exceptions to the early distribution penalty tax, which means, in other words, IRAs are created for a specific reason, right? Retirement. So what if we want to take it out before it's considered retirement? What happens to us? We're going to talk about those tax consequences of traditional and Roth IRAs. So whenever we take the money out, what might we be looking at as taxable income on that 1099-R that we're reporting? Finally, we're going to talk about required minimum distributions, what that means, as well as that required beginning date for those required minimum distributions. And then finally, we're going to discuss the thing everyone loves the most, I'm quite sure, those reporting deadlines, when we have to get in that information to let the IRS know about those distributions for the IRA owners. All right, so the first part here we're talking about are the distributions. Whenever we take a distribution, or more commonly known as a withdrawal out of our IRA, we can do this at any point in time, no matter your age. We can always take money out of our IRA. That is one thing that is really different than qualified retirement plans, is we're not subject to wait until an event that the IRS deems worthy of us taking funds out. No, we can always take that money out of our IRA. But what may happen is we may be subject to some different taxation rules. So the two types of tax that you're going to be dealing with are going to be income tax and early distribution penalty tax. The income tax is going to be those federal and state taxes that you see. You know, I had a friend that whenever they got their first paycheck, they were like, well, who is FICA and FUTA and why do they keep taking all of my money? That's what we think a lot of times, you know, that's where all that money goes. It goes back in to the system there, and they take that income tax, you know, for us making money. They take that from us there to where they have that to fund the government and things like that. Then the penalty tax is going to be one where if you take money out too early, according to the IRS, because this is for retirement, remember, then you're going to be subject to a 10% penalty tax. So these are the two types of tax consequences that you may have on an IRA distribution, that income tax as well as early distribution penalty tax. We are responsible for reporting that distribution on that 1099-R to where the IRS knows, hey, by the way, I might be subject to taxation. Hey, you have to make sure you take money from me. In other words, that's what that's telling them. And that is how, as a financial organization, we help that IRA owner make sure the taxes are done properly there. Now, something that is different, while we report the information of what was taken out, it is the IRA owner's responsibility to determine the taxable portion of each distribution. And they also are responsible then for paying any taxes due, as well as that early distribution penalty tax, if that is something that they are subject to. So that is their responsibility. It's just our responsibility to report that a distribution occurred. And that's what moves forward with that. So here are the steps in dealing with an IRA distribution. Whenever someone wants to take a distribution from our IRA, what's the first step could be? Well, obviously they have to contact the financial organization to take a distribution. We are not just going to automatically take a distribution for them unless we have been told to do so for them. So it is that IRA owner's responsibility to reach out to make that request to the financial organization for the distribution in whatever format that might be. Financial organization will then document that distribution, possibly with a withdrawal form. Most probably use a withdrawal form of some sort. Some may just do it in their system, but it is something that needs to be documented. That way the request is shown through the system. And then from there, they process that distribution. Or in other words, they make sure that the money is going to go to that IRA owner. That next step is going to be that IRA owner receives the money. They get the money in their hands there. And then the final two steps, we've got the financial organization will report the distribution to the IRS and the IRA owner. 1099-R we're talking about. And the IRA owner will document that distribution on their tax return. Remember, they will make sure that they're going to be taxed on the portion they need to be taxed on. It is their responsibility, not yours. So it is important that they do that step on their own. This next slide we're talking about here is talking about providing a withholding option. This is something that has recently changed to a degree, at least that we're working with. It's always going to be something that we have to do. You must notify that IRA owner and beneficiaries of their right to withhold or waive withholding on an IRA distribution. If the distributions in aggregate are total of 200 or more. If they don't make an election, then we're required to withhold at a rate of 10%. So if they don't waive their withholding or they don't elect a higher amount, then we are required to hold at least 10% if no election is made. And this is on non-periodic distributions that we're talking about. And we'll talk about the difference between the two here really quickly. But withholding can be waived. We can say, you know what, I choose to waive withholding. I don't want to do anything. Maybe I'm paying my taxes elsewhere on it, something to that degree. Sorry, kind of skipped ahead on me there. But that is an option as well. What is withholding exactly? So I talked about 10% withholding. That is the typical, that's the default that we're dealing with. But typically, what withholding means is it's a way to prepay your taxes. So I like to think of the IRS having a little piggy bank at, wherever they are, wherever they're located, a piggy bank in the cloud, we'll just say that. And every time that we put money in with our taxes, it always goes into that little piggy bank for us. So in other words, when FICA and FUTA takes our money, like my friend said, that goes into that little piggy bank with our name on it. Now, that piggy bank is just sitting there being held. Nothing is happening to that piggy bank until tax return season comes. We're filing those taxes, noting I had this much in income. Then the IRS says, well, you owed us this much money in taxes. So what they do first is they go to that little piggy bank that they had saving for us, and they take dollars out of that piggy bank. If you have enough money in the piggy bank to cover your taxes, great. If you had too much in, that's when you get that tax return. If you didn't have enough, that's when they'll request additional money from you. So in other words, it's an additional way to set money aside for that. So whenever we withhold, this money will go to the IRS and sit in that piggy bank. There's no way to get that back until tax return time. It is something that, it is required. It applies to beneficiaries, IRA owners, anyone, anyone at all who takes a distribution from a type of IRA, they are subject to some type of withholding. They can either waive it, 10% or more is typically what we have been dealing with. I did mention there are different types of distributions and different types of account the money can come out with. We are going to talk about that here in a little more detail, but let's talk about this part first with the withholding rate. Withholding rate for years has always been you could not take less than 10% unless you were waiving. So in other words, I couldn't take 9%, I couldn't take 2%, I couldn't take 3%. I had to take at least 10% or more or waive withholding completely. Okay, so this has been the way it has worked for years and for years and years. Well, here in 2021, the IRS indicated that in 2022 tax year, the form that we have been using for taxes was going to be split into two separate forms. We'd have a W-4P and a W-4R moving forward. With that information, there are going to be some changes in the requirements of reporting, but the first step to knowing which form would be used would be if you have a periodic or non-periodic payments. Okay, so a periodic payment is not exactly, to me, the difference between the two has always been slightly confusing because it took me a while to kind of grasp what it meant. Periodic doesn't mean as simple as it sounds. You would think, hey, an RMD might be a periodic payment because they request it yearly, right? No. In this case, periodic is actually meaning those annuitized distributions from an IRA annuity. Those would be those periodic payments. So that steady stream of payouts that will not change. IRAs are typically, for the most part, considered to be those non-periodic distributions. Why? Not because you can't take them periodically. No, it's more so because they are considered to be able to be payable on demand. So even if we have this set amount scheduled every year for that RMD, we could always request more. Could always request, well, we wouldn't want to request less, but we could always request an additional distribution later on, things like that. So it is payable on demand. We can get that money out and we can vary and stop those payments if we want, even though, they might be in trouble with that RMD for other reasons, but they can do that. So those non-periodic distributions are going to be subject to a withholding rate of 10%. They are required to withhold 10% from most non-periodic distributions, unless the individual receiving the distribution elects that greater amount. Now, something different is with the periodic payments. we are going to continue to use the W-4P. Non-periodic payments, so those IRA distributions we're talking about, those are going to be starting to be reported on W-4R. That's going to be required now in 2023. Beginning of 2023, we'll have to start using that W-4R. Until that point in time, we are still allowed to continue to use that W-4P. So the individuals that already have the W-4R ready to go, we can start doing that, but it's not required until 2023. So it's still something that you have to let the IRA owner know that they have the ability to use. One thing that is very different on the W-4R is that it actually allows an individual to elect 0 to 100% in withholding. So this is something very different, and we're still kind of filling it out to see exactly how that's going to be handled moving forward. But it appears that they're going to be allowing IRA distributions to be able to be withheld at any rate, which is something really, really different. Until that point in time, until 2023, we were going to have to be able to use that W-4P form or a substitute form. If you have IRA owners fill out a withdrawal authorization or a census withdrawal authorizations, have that withholding notice on them, and they do let them know that information as well. So it is something that is automatically provided at the time of the distribution. Those individuals taking those regular distributions, you may send out an additional notice letting them know, hey, you need to be aware you can change your election. The big thing on withholding is that we notify them of this election, ability to change it regularly. The election stays in place though, until that IRA owner chooses to withdraw that election or change that election. So in other words, if I elect to do 20% withholding on my distribution today, every distribution following that time period would have a 20% withholding election automatically applied on it. Unless I were to receive an election form and then I note, hey, no, I want to only do 10% moving forward, something to that effect. So something you see that causes some issues a lot of time would be maybe an individual wants to withhold 100% on this one distribution. Regularly, they hold 10%, withhold 10%, 10%, 10%. This year, they want to withhold 100% on their RMD because you know what? They don't need it and they know they're going to have a lot of taxable income this year. So they send it off to that piggy bank with the IRS. Well, if they don't make an election to change it back to the 10%, then every future election is going to be withheld at 100%. So it is something important that we always say if someone chooses to do 100% at some point in time, you might want to ask them, is this what you want to do moving forward? If not, go ahead and fill out another election form to make sure we have that on file. That way we can change it back to 10% moving forward. So it does stay with them until the point in time that they are no longer subject to, they're no longer taking distributions. So that election just stays with them permanently until that point in time. So that is the federal withholding we talked about. State income tax withholding only applies, you only are required to do it if both of the following are true. Your financial organization has a branch or an office in the state, and the IRA owner or beneficiary is required to either file an income tax return in the state or as a state resident, depending upon that state. So most cases you're going to deal with is if you have a branch or an office in the state and the individual's state resident. Other times it might apply would be you have a branch or office in the state and they file that income tax return. You may ask, why are they doing that? Well, let me give you an example. Missouri is one of those states there listed on the chart. So I originally lived in Missouri and my husband's in the military, as we've talked about, and we moved to Arizona. That year, I actually continued to work for the Missouri company that I was working for previously. I just did it remotely in Arizona. And that year, I actually had to file income tax return in Missouri and Arizona because I had both worked in Missouri and Arizona that year. So that's why you might be dealing with it in regards to that, and it might be subject to withholding on something like that. Remember, it's both. So if you don't have a state or office or branch in that area, then it doesn't apply. Okay, so that's the only thing. If you're wanting more information on this stuff, I would always say, you know, there's a job aids that can be found. It talks about the chart, including a chart of the state requirements for withholding that goes through each of them. It's very handy. I think it's on maybe page 43 or 44 there of your job aids. It kind of varies according to which version of the document you're looking at there. So it should be in that job aids section that goes through the state withholding requirements. All of these states that are in blue have some type of state withholding requirement. You should, if you do conduct business in that state, then you should review those withholding regulations in those states to determine if you're also required to comply with those states. If you need more information on it, you want to contact that state's Department of Revenue of Taxation there in order to make sure you get that proper information moving forward. The next two slides here are going to be showing that state withholding guide that I talked about. Oh, it looks like it's page 29. I was really off on that job aids on this one. Sorry about that, guys. So job aids, page 29. Here's what you're looking at for that state income tax withholding guide for IRA distributions. Whenever you look at it, note that it also says in the case, you have to have both for the things we talked about. You can see here when looking at this that there are crazy different types of state withholding that you're dealing with. For example, Arkansas IRA distributions are subject to state withholding at 3% of gross pay unless the IRA owner elects no withholding. And you've got Montana here with IRA distributions are subject to state withholding when an IRA owner elects state withholding and specifies an amount. Michigan, look at the length of this one. You can see that it is already different here.
Hey, Steph,
Go ahead.
Is this particular page in that supporting booklet that you sent? If so, what page is it?
It is. It's in the back of the booklet. So there's different page numbers according to which section you're in. So it's in the job aid sections of it at the back, and it's going to be on page 29. So you'll have to go all the way through. Let's see how many pages.
So that's page JA29 for anyone who wants to jump to it using
Yes.
Yeah.
Awesome. Thank you. I appreciate that. So JA29 is how he found it there. So if you want to look at and jump towards it there, you can see it. And it goes into detail, like I said, on every different state that has requirements. Now this does change. So this isn't a permanent thing. States will change the amount of withholding that they have apply, things like that. Note that Michigan's, like I said, is subject to state withholding at 4.25% of the gross payment unless the IRA owner provides a MIW4P. So what this does is it's a specific form for Michigan that you're requesting a waiver or changing that information. So if they fill that out, then they might not be subject to the taxation, the withholding taxation of it there.
And that's required to be collected anytime you deviate from 4 1/4 in Michigan.
Correct, unless they file the W or the MIW4P. Correct.
Has that always been the case, or is that a new requirement as of recently?
It's specific to any taxable distribution of an IRA received by an owner or beneficiary after December 31st, 1945. So if that owner, so typically speaking, those RMD individuals you're dealing with wouldn't have had it for a really long time. You know what I mean? So for many years, they wouldn't have been subject to that until recently. Good question. And I don't know, like I said, we don't focus a lot on state law specifically. So if you want more information, you can contact that state, the revenue office of the state, and they can give you more information specifically on Michigan's too. Now, one thing we talked about in the beginning is withholding, and we talked about early distribution penalty tax. So you don't want to confuse the two. While they are both 10%, withholding is something you collect as a financial organization. Remember, we take it from that IRA owner and it goes to that piggy bank with the IRS. The early distribution penalty tax is not something that we would collect ourselves there. So notice other states will have something even saying that if you have federal withholding performed, then you are required to do state withholding. There's no getting out of it. So just interesting to see the different rules if you want to look over those there. All right, so now we did withholding. That's the money we collect as a financial organization. Our early distribution penalty tax. When does that apply? Well, the whole purpose of an early distribution penalty tax is IRAs are made for what? Retirement. So what is the IRS doing to try and keep the money in the IRA? They are creating this penalty that is going to apply if you take money out too early. In other words, they say that, you know what, if you take money prior to age 59 and a half, it's obviously not for your retirement. It's not for you living in retirement. It's for something else. You're doing it for another purpose. So because you're taking it out for something unrelated to retirement, we're going to say you owe a penalty tax on it, an additional 10% tax. It's money you're not going to get back. It's just a 10% tax on that. It does apply to that taxable portion. So if something is a non-deductible contribution and we've already made that contribution and we've already paid the taxes on it, we're not going to be subject to the penalty tax on that portion. But everything else that is taxable, we would be subject to paying the penalty tax on it. Financial organizations cannot collect this. There are some reasons that the IRS says, hey, even though you're under the age of 59 and a half, we're going to allow you to take the distribution out if it's for one of these reasons. And we'll talk about those in a little more detail here in a minute. But the important thing to remember on this part is that this is age specific. Okay, so it is 59 and a half, exactly 6 months following their birth date there. So if we take it earlier, if I take it at 59 and 2 days, doesn't count. Doesn't matter that I turned 59 and a half that year. I have to already be 59 and a half at the time of taking distribution to not be subject to this penalty tax, unless I have another penalty tax exception there. So it is, like I said, specific to that taxable portion. It's the IRA owner who is responsible for making sure they pay it. They would need to file a form 5329 to tell the IRS, hey, I know I owe this penalty. So I need to pay that extra 10% on there. Whenever you're looking at that 1099-R, you're dealing with a traditional IRA, you're going to have that code 1 early distribution, no known exception. What that does is that triggers the IRS to know, hey, they should be paying a penalty tax on that. I should be receiving a 5329 from them on that information. One thing an IRA owner might ask you if they can do is they might say, hey, can I go ahead and withhold that additional 10% because I know I'm going to owe it later? You can do that. That is fine. You can withhold that additional 10%. It just goes into the little piggy bank. And it's not specifically designated for that penalty tax, but they're kind of finding a way to prepay that penalty tax in the future. So they have the extra funds in there for it. So Adam was born on July 29th, 1962. When did he attain age 59? So when did he attain age 59? Very good. So July 29th, 2021. How do we know that? We take 1962 and we add 59 to it. That gives us 2021, and we know his birthday's July 29th. So when did he attain age 59 and a half?
January of this year.
January 29, 2022. Very good. Yes. So he attained age 59 and a half exactly 6 months after that. So if Adam came in and he took a distribution on December 31st, 2021, would he get the penalty exception? Or would he be subject to the penalty is another way of saying it. If Adam took a distribution in December of 2021, would he still be subject to that penalty?
Yes.
Very good. Yes. Even if he took it January 28, 2022, he's still subject to that penalty unless he has a penalty just tax district exception. Okay. But for 59 and a half only, he is subject of that day specific, very specific on that one. Why 59 and a half? No clue. Yeah, I know, super corny, guys, sorry. But yeah, it's a way to remember 59 and a half. So, all right. So I mentioned there are other ways to get around this penalty tax. What are those other ways? So the first one, you've got age 59 and a half. The next row right here, I like to think of them as all provable with you, a financial organization. Okay. The best way to describe that is, are you going to know if that IRA owner is deceased whenever they're taking that distribution? Yes, you are. You need to know that prior to giving money out to a beneficiary. How do we prove this? What are you required to receive in order to make a distribution according to death? What are you required to receive in order to make a distribution for death? In other words, to make a distribution to someone other than the IRA owner.
The death certificate.
Yes, very good. Death certificates. Guys, why is this important? Well, let me tell you a couple stories here. I was once talking to a financial organization, and they called in and they said, hi, we kind of have a little bit of an issue here. So what they went through is they then explained to me what had happened. Well, the beneficiary of this IRA came in and they provided a newspaper clipping of the obituary showing their person's death there moving forward. So the teller was a new bank teller there. They processed the distribution, gave all the money to the son of this individual who was the full beneficiary. A week later, guess who rolls in the door? Yeah, that IRA owner, the dad of that beneficiary. And he was pretty upset that he had no money in his IRA anymore because he didn't take a distribution and he wanted to know where it went. Well, they told him it went to his son, who was the beneficiary, because they received that information. Needless to say, that son was nowhere to be found after that. And the IRA owner's money was gone, and it was the financial organization's fault for not getting that proper information. Another reason to have it and request a certified copy of it is this other situation that happened. This actually happened to one of my coworkers. They received this call on the IRA lines where they were talking about it, and they said, financial organization called, similar situation, except the wife came in and she provided the death certificate, and we'll say for this case, it was John Doe, and she provided the death certificate for John Doe. They processed it. It was certified, or it wasn't a certified copy or anything like that. Well, it turns out that it was actually John Doe the first that had died, and John Doe the second was whose IRA this was for. Therefore, they processed this according to a slight change from a non-certified copy, And guess who is gone now, running for the hills with all the money? The spouse again. So just remember, it's always important to get that death certificate prior to processing any distributions to those beneficiaries. This does allow for, like I said, no penalty tax. So that doesn't mean the IRA beneficiary is not going to pay any taxes on it. It just means they're not subject to the extra 10%.
So did no one verify the social security number on those death certificates?
I asked the same question, and the person couldn't, like at the time, they couldn't tell me. They didn't remember because it had been a while back. But she said that it thought it was something to do with they'd either like changed it in some manner, or they're like, or just the person was just careless, you know, like, I mean, that's all it boiled down to it. But she goes, there was some kind of confusion on the teller's side that was just ridiculous. So yeah, just important to remember, like you said, check that social security number, make sure it lines up, everything like that.
And was it determined that it wasn't certified? Was it not with the notarized raised
Correct.
statement?
Yeah. Mm-hmm. Yep, you're exactly right. So like I said, I don't know if they had some way of, I mean, I guess back in that point in time, they probably wouldn't have all the Photoshop techniques that we have nowadays that people can do weird things with. So probably just a rescanning or something like that with a different number over it or something. I don't know. I'm not in the mind of a criminal. I can't figure it out. So, but yeah, so that is death. So in order to report it as a death distribution, which you would report it differently, would be a code 4 distribution, we'd report as a death distribution. We need that death certificate in order to do so. Disability is the next one we're dealing with. And with disability, they need to provide some form of proof in order for you to report it that way. A Schedule R, which is a credit for the elderly or disabled, is a good thing that can be provided, or a physician's statement. This again allows for them to get that penalty tax exception. They still have to pay taxes on the rest of it, but they get the penalty tax exception. An IRS levy would be when the IRS comes in and says, hey, we're taking your money because you haven't paid such and such. The IRS is the only one that can do that with IRAs. And isn't that nice of them not to charge us a penalty if they're taking our money? Very nice. So that one you would have proof of. You'd want to have that letter on file that they were given saying that it was an IRS levy. Substantially equal periodic payments are something that they would actually set up with your financial organization. What it does is you have different ways that you can calculate this, but what it boils down to is you're getting a set amount of money each year, and you're saying that that value will remain unchanged. We can't make any changes to that account once we start these substantially equal periodic payments, and they have to be done at least annually. So in other words, I could no longer make contributions to that IRA if I have substantially equal periodic payments set up with it. I would have to do it to a different IRA. But that's what this is that we would know that they set it up and they're doing those distributions as needed from there. The bottom group down here we're about to go through, all of those are things that are not provable between the IRA owner and the financial organization. Or while it may be provable, it would be so much information, we don't want to keep track of that for them. They handle it on their side of things by filing that 5329, requesting the waiver and explaining why they deserve it. Medical expenses is one of those things. Unreimbursed medical expenses that exceed 7.5% of adjusted gross income can be a penalty tax exception. So case in point, do you want to figure out what's 7.5% of their adjusted gross income and then make sure that their medical expenses are more than that and then have all that proof? No, too much. So that's not something you're required to do. The next one is going to be those health insurance premiums following unemployment. Now, the IRA owner must have received unemployment for at least 12 consecutive weeks prior to being able to use this as a penalty tax exception. Then they can. The homeowner cannot have had, the The next one is the first time home buyer expenses. In this case, that home buyer cannot have had ownership in a principal residence for 2 years ending on the date of acquisition date. So the titling of this one has always been interesting to me because it says first time home buyer expenses. So to me, that means a person is buying a home the very first time, right? That's not according to the IRS rules. So I could technically even be a home buyer after 2 years after I bought my last house, right? After 2 years after I sold my last house. So I sold my last house there in August of this year because we're moving to Maryland because my husband, you know, with the military and everything like that. And in the process of that, that ended my owning of that home. So now I would have to wait 2 years to be able to use this as a penalty tax exception if I wanted to. Now note that this is a $10,000 limit per IRA owner per lifetime. They can use it for children, their children, they can use it for their parents, they can use it for grandchildren, things like that, but they cannot do more than 10,000 per their lifetime. So now I'm going to give an explanation of that a little bit. So I am currently pregnant, so if I'm huffing and puffing, that is why. I am 31 weeks along. So in that time period, I told you my daughter's name is Blakely. Well, I'm having a son. I will not say his name because we like to keep it secret. But anyways, moving forward, if I were to take a distribution of $10,000 for my daughter, Blakely, I could do that and have that as a penalty tax exception. Remember, I'll pay the taxes on it, but I'd get no 10% penalty on it. So I could take it for Blakely, but I wouldn't have any money that I could take for my son then moving forward. I wouldn't be able to give him money for that first time home buying expense. Okay. Even if I owned a home right now and I wanted to take a distribution of that $10,000 to give to my daughter for that purposes, I could, because she doesn't own a home. She's only 2, guys. But anyways, she doesn't own a home. So she would be a first-time home buyer and we could use that for those expenses. Now, if my husband also wanted to take a $10,000 distribution from our IRA and get that penalty tax exception and give it to our daughter, we could both do that. So in total, she could technically get $20,000 from us for that first-time home buying expense. Again, that wouldn't leave anything for my son if that were the case. So he would not be able to get anything that way. It's per IRA owner is how that works. So if I were to use it now on my daughter, I wouldn't have it later on in life on my son. Could I use $5,000 now on my daughter and $5,000 later on my son? It's a possibility. The important thing is only $10,000 total for that penalty tax exception.
Can you get that, let's say you sold your home in August, wait 2 years, you're eligible for it, use it in what, 2024 and then, or 2023. Could you then sell that home and then get this again? Or is this a one-time only in your lifetime? Or is it every 2 years post-house selling?
It's a $10,000 per lifetime. So if I used it in 2023, like you mentioned, and I took only $5,000, then I could wait another 2 years or whatever, or then use the other $5,000 for my daughter, or however I wanted to handle it. But the important thing is the dollar amount is a $10,000 amount total. You never get to do that. Yeah, per lifetime.
You can't just get into every 2 to 4 years flipping houses and keep pulling in 10 grand.
Correct. Yeah. Good point. Yeah. So the next one here we have is those higher education expenses. There is no set amount on this. You can take whatever amount you need to for higher education expenses. So whenever you get to that time period, if you need to take money out of your IRA, you still have access to it, still subject to tax, not subject to that early distribution penalty tax there. So that is one thing That is a benefit there. You can use it for tuition, fees, books, supplies, equipment, everything like that. Sometimes even possibly room and board. So it is a good expense there that can be used. The IRS deems worthy of taking money out of your retirement account.
So ultimately, it's up to the IRS to determine what's considered a qualified higher education expense.
Very true, very true. So you as a financial organization would not be responsible. Again, they'd file that 5329 and say, this is my higher education expense. Chances are, and this is not something we deal on our side with, but I would imagine they'd have to provide proof too, like some type of receipt showing that information, that it was going towards that. Great question.
The onus would then remain on the taxpayer, not the institution, financial institution.
Exactly, yeah. And somebody asked the question, can it apply to student loans? Great question too. No, it cannot. So the thing about higher education expenses is that it has to be current year education expenses. So expenses for the year you are distributing the money. Great question too. Someone else asked, does it have to be your own education expenses or can it be a spouse, child, etc.? Yeah, so remember I mentioned first time home buyer, you could actually even go and do it for your parents here, or your grandparents even. I could have bought it for my grandpa before he passed away if I wanted to buy a home. Higher education expenses are similar, except you can't do it for your grandparents. So you can do it for your child, your spouse's child, your grandchildren, but you can't do it for your grandpa. The way I remember it is, for some reason, one of my coworkers, whenever we were learning now about this, she goes, oh, so you can't buy grandpa's college. And I'm like, well, true, you can't buy grandpa's college. So in other words, you can buy his house, but you can't buy his college and count it as a penalty tax exception.
But can you buy your parents' college?
You could. Mhm.
Okay.
Yep. Great questions. Now, again, not your responsibility to determine if it falls into it, though, between them and the IRS. Qualified reservist distribution. These are distributions that say somebody is not on active duty military, something happens, they're a reservist, and they get called to that active duty for a period of time, or even they're just called to, reservists have certain time periods where they have to kind of go on active duty there. So that would be a time period where they'd be able to do distributions penalty tax free. And they even get some options where they might be able to pay it back for a little bit of an extended time period too. But they could take that penalty tax free, not tax free, penalty tax free. The last one there is qualified birth or adoption. This is a new one, and it is for tax years beginning after December 30. Wait, sorry, I'm saying the wrong one. This was begin for 2020 on. So you could do the penalty tax exception from 2020 on. Okay. Now let's talk a little bit about this one because it is different. This one is for, like I mentioned, it has to be a qualified birth or adoption. So what that is specific to is really, it's saying it has to be for an individual who is under the age of 18. We can only use it for that type of individual. If we're adopting them, in other words, if I'm doing it for a birth, then it has to be within a year of the birth. So I told you guys my daughter's 2.5 now, actually. I could not take a distribution, a penalty tax distribution for this, penalty tax free, because she's over 2.5 years old now. So she was born 2.5 years ago. I can't do a distribution and call it a qualified birth or adoption distribution now and get that penalty tax exception. I could, however, take a distribution now for my son and use that as a penalty tax exception. This is one that is per event is how it's worded. So I could have done, if my daughter was during that time period, I could have done one for her and then my son too. I would have been allowed that. And it's $5,000 in aggregate from those IRAs and retirement plans. So I'm only allowed $5,000 per event. So in other words, if my son, I use 5,000 for my son, and then I later have another child, which we don't plan to, but that's besides the point, then I could also do $5,000 for that other child later on down the road. If you have twins is a typical question. Technically it's per birth there, so you could do it for each one of those, do 5,000 per individual. And if you want to get the extra money, technically your spouse could do the same thing. So they'd be able to. So it's per event there, per IRA owner moving forward. The adoption is something that's a little more specific. Like I mentioned, they can't be 18 or old, or they can't have to be under 18 there. And with that one, it can't be like you're adopting your stepson into the family. That doesn't count. It has to be kind of you're adopting someone completely different there. And the question I just received, would the client have to wait until the child is born to take this? No, it's a year on either side of it. So it's 12 months. It could be 12 months before the birth or 12 months after, technically. I think you probably see most people wait 12 months after. There's some time in that range, but there are some people that might take it ahead of time. So yeah, it's $5,000 per birth. Yeah, exactly. And the question is, what if something happens and you lose the baby before birth? You know, that's something that I don't think even has really been addressed at all throughout any of it. But I do think that is probably a concern when it comes down to it, because then you've taken this money out and you now no longer have that qualified birth. Now, is that something that the IRS is probably going to look into? I'm going to guess no, but I don't do the taxes either. You know, I think there's probably a lot of things people can get away with just under the guise of best intentions kind of thing. I wouldn't suggest it, but I would say that there is a lot of things that can happen that way. All right, so now we've got a section here on withholding and early distributions. Everybody take a couple minutes here and go ahead and start answering these questions on your own. And then we're going to get back together here in 2 minutes. Well, let's make it 3 minutes on this one, and go through all of the questions together to see if everyone's on the same page.
She can take the money and withhold whatever she wants because she's over 59.5, right?
Patricia. So Patricia, age 65, is drawing $10,000 from her IRA today to cover expenses for her trip to the Galapagos Islands. If Patricia elects federal withholding, can she withhold 8%? Why not? And you asked what? Sorry.
I said she can withdraw that because she's over 59.5, and she can withhold whatever amount she wants, right?
So typically speaking, yes, for years and years and years, we've been able to withdraw. The withdrawing part is correct. She can withdraw it. No penalty tax is going to apply. You're right, because she's over 59.5. As for withholding election, can she withhold 8%? Why not? With the rules in the past, we've always been able to only hold 0 or 10. So no on the 8%. Moving forward now, I still think it's something that I would say is a little bit in the air on. It's a possibility they might be able to hold 8%. So possibility. Now, what is the maximum rate that she may withhold for federal income taxes? It's the maximum amount that someone can withhold for federal income taxes.
100%, but that would defeat the purpose in this instance.
Correct. Yep. Very good. Can Patricia waive federal income tax withholding? Can she say she doesn't want to withhold anything?
Yes.
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 Very good. Yes, she can. Now we're talking about Jill. Jill's at your financial organization to withdraw $15,000 from her traditional IRA to buy a car. She will be 59.5 next week. So before we get to the question, can Jill withdraw this money, even though she's not 59.5?
It's
Yes.
just penalty.
Yes.
Yes,
Yeah.
exactly right. She can withdraw it, even though she's not a 59.5 or older. Now, is she going to be subject to that 10% early distribution penalty tax? Why or why not?
Today, yes.
Yes, but it's not 59.5.
Very good. So yes, she would be, because she is not 59.5 at the time of the distribution. So say Jill, just wait until next week. What portion of the distribution is subject to the early distribution penalty tax? So in other words, are we dealing with the taxable portion, the non-taxable portion, the earnings? What are we doing?
Taxable.
Very good. Yes, the taxable portion. And then number 6, we're still talking about Jill here. Should we collect that early distribution penalty tax as a financial organization?
No.
Yes, you guys are exactly right. No, you do not collect that. It's not your responsibility. And I love that I saw some capital letters on that. That's great. Good job. So now this one, which of the following are exceptions to the 10% early distribution penalty tax that Jill could possibly use if she is qualified? Higher education expenses, is that one?
Yes.
Good. Landscaping,
No.
addition to her house.
No,
Good. Now, why is that not going to count as first time home buyer? Why can't I do it? It's about a home, right?
He already has the home.
Very good. Yes, you already own the home. It's an addition to your house. You're not buying it. You already have it. Vacation,
no,
disability,
Yes,
Yes.
proven.
first time home buyer expenses.
yes,
Yes.
Having not been a home buyer for 2 years.
There you go. Yep. So it has to meet the first time home buying expenses. Actually, you have to be qualified for that distribution. Very good. All right. So that's the early distribution penalty taxes we're dealing with. So now let's talk about distributions as a whole on those traditional IRAs. Generally speaking, traditional IRAs are subject to income taxes. Why is that the case? Because what is the extra tax advantage of a traditional IRA that Roth IRAs do not have?
They're deductible.
Exactly. Yes. So because they are deductible, what that means is we technically have that amount that would normally be considered taxable income, but we are instead they're putting it into a traditional IRA. And we're telling the IRS, hold off, don't tax me on this amount because I'm eligible for the deduction. Hold off, and you can tax me on it when I take the money out instead. So we don't get taxed at the time of putting it in like we normally would. That is a deductible contribution. We get that benefit, we get that deduction on our taxable income for the year we contributed. So that is one type of distribution that you're dealing with, those deductible contributions and earnings, and they're always going to be subject to income taxes, always. Always on traditional IRAs. Deductible contributions and earnings are always going to be subject to taxable or as taxable income there at the time of distribution. Okay. What's not subject to income taxes are going to be those non-deductible contributions. So those are the ones where I'm not eligible for the deduction, or I was eligible, but I didn't want to take it. And I submitted it to a traditional IRA, put it into that traditional IRA. So it's money I've already been taxed on. So we use that number 100,000 as our taxable income amount. Whereas with the $6,000 deduction, we would be 94,000. I made a $6,000 non-deductible contribution, I'd still be at 100,000 in taxable income. So we are going to not be subject to taxes then at the time of distribution because we already paid the taxes on time at the time of contribution. Now, is this your response? Sorry, go ahead.
Whose responsibility is it then to track those deductions and non-deductible contributions?
Good question. Yeah. So it is not your responsibility as a financial organization at all. You're not responsible at all for knowing this information. It is strictly the IRA owner's responsibility that they know when they take money out, if there's a portion of that that's considered non-taxable. And in order to do this, they use an IRS form 8606. And they would need to file that yearly to make sure they keep up with those non-deductible contributions. That way, whenever they go to take a distribution, they can attribute a certain portion of that to non-deductible and a certain portion to deductible in earnings. But it is something that I generally on this part say I would, while they could do it all their own on the 8606, I'd recommend them talking to a competent tax advisor to make sure that they have that taken care of properly on that side of things. So that's the 8606. So we got the 5329. Remember, that's for penalty tax exceptions. And the 8606 for tracking those deductible and non-deductible contributions there, okay? So keeping track of what type of money it is on that. So let's talk Ted here. Ted's withdrawing $1,000 from his traditional IRA, which contains $9,000 of regular contributions, $8,000 deductible, $1,000 non-deductible, and $1,000 in earnings. It is Ted's responsibility to make sure he tracks this. Why? Because he has to know what portion is going to be taxable and what's not. So here his tax advisor will calculate taxable portion of the distribution on a pro rata basis when he files his tax return. The $1,000 distribution will represent a portion of each. Now let's talk about what that means here, okay? Think of a traditional IRA as a coffee cup. Who likes to drink coffee or tea or anything like that? Sure, everybody likes one of the two, some sort. I love both. I'm going to tell you a little bit about how I like both of them, okay? My cup of coffee, we'll say it's this size cup. It comes with about this much coffee and this much cream, right? So about half and half cream and coffee there. And then I like to add a little bit of honey. And don't forget about like the 3 packages of sugar that you put in there too. So once I pour it all into my coffee cup, I got my black coffee, my creamer, that's that white creamer, and I've got my white sugar packets, and I've got my beautiful yellow honey that goes in there, all of it mixing together into one perfect combination to make me able to drink a cup of coffee. At that point in time, can I go, I'm going to take out just the sugar from this cup of coffee. I want to drink only the honey in this next drink. No, it's all been combined, all swirled into one. We have a cup of coffee that's mixed with everything. There's no taking out different portions of it to say, I only want this. So in Ted's case here, he had traditional IRA money that had deductible money and non-deductible money. There's no way to say, I only want to take out my non-deductible money in this distribution. I don't want to pay taxes on this distribution. Every distribution he has is going to have a pro rata portion of the non-deductible, the earnings, and the deductible contributions. So there's going to be a portion that's taxable and not taxable. Now you might say, what if he kept those accounts separate? And he had account only with his non-deductible contributions and one only with his deductible contributions. The IRS thought ahead and they said that IRAs, traditional IRAs, are considered aggregately across the board for the purposes of this pro rata distribution. So they are not allowed to do that. Now, this does take us back to that point that it is not your responsibility to know that. Okay? You report it the same way, no matter what. It's their responsibility for tracking that they have had non-deductible contributions in their lifetime, and that a portion of that would be considered non-deductible and a portion would be considered the deductible or the earnings. Does that make sense? All right. So now we have RMDs. What are RMDs? Well, it stands for required minimum distribution. That is exactly what it sounds like. It is a required amount, a required minimum amount to be distributed each year. What the IRS says is, you know what, I get that we're giving you this tax advantaged account where you don't have to pay taxes on it. But you know what, eventually I want to get my money. I want to get what's mine. So they're going to make you take that money out where that can't stay in that tax favored account forever. They want you to get the money out of there eventually. So traditional IRAs and those, if you're familiar with simple IRAs, they're required to take what's a mandatory distribution starting at a certain age. So I like to think of this in kind of a timeline, and we'll use that timeline here in a second. But what you need to know is for RMDs, there is called a required beginning date, and you're required to begin taking these distributions by that certain time period. For birth dates before July 1st, 1949, RMDs were mandatory beginning the year the IRA owner attained age 70 and a half. So your required beginning date would actually be the April 1st following that time period that you turn 70 and a half. Now, starting here, which really starts in 2020, birth dates on or after July 1st, 1949, those RMDs are mandatory beginning the year the IRA owner attains age 72. The way this, these dates are great, and they tell you exactly what I'm going to tell you in short here. The way I like to keep track of it is, was the IRA owner taking RMDs prior to 2020? Were they required to begin those RMDs prior to 2020? So in other words, did they turn 70 and a half prior to 2020? If they did, 70 and a half is the year, the age we have to work with. If they turn 70 and a half after 2020, they get that extended period of 72. Okay, so in 2020 on, if they turn 70 and a half, they get to 72 to wait to begin taking those required minimum distributions. Now, I mentioned we get that extension of time period here for age 70 for whenever we have that first distribution. We actually get until that April 1st deadline of the year following the year we are required to take that distribution. So this shows an example here. 2022 is going to be considered my 72nd year. That is considered my first RMD year. So it is an RMD for 2022. I get, though, until April 1st of 2023 to take that distribution because it's my first distribution. That is the only year I get an extension on it. Every other year, I'm required to take a distribution by 12/31 of the end of the year. So if I take my 72nd distribution, my 2022 distribution in April of 2023, I still have to satisfy my 2023 distribution before the end of the year. So that would put me taking 2 distributions in the same year there. Okay, so even if I turn 72 on December 29th, 2022, I get until that April 1st deadline, but it would put me taking 2 RMDs that year.
Is the April 1st deadline for that to allow 2 weeks to file the temporary paperwork and taxes on that distribution?
It's a good question. I'm not really sure. I don't think they have a specific reason on that. I think it's kind of one of those things that they've just always had there to give you that extra time, maybe for just getting familiar with the fact that you have this thing due? Yeah, that's a good question. But yeah, it's only for that first year you get that extension period. So I've got a couple examples here. If a date of birth was 9/15/1950, when is my 72nd year?
2022,
Good. When's my required beginning date then?
April of 23,
Good. And when's my next RMD deadline if I take that April 1st, 2023?
end of the year of 23.
Very good. So when taking distributions, you will typically see things divided into, especially once you get to beneficiaries, divided into things like, was the IRA your owner before or after required beginning date? April 1st is that required beginning date that they're talking about there. That's whenever they refer to that. And we don't really go over that in this course, but I just want you to be familiar with that. We do go in that in detail in the advanced course. So if you're here with us tomorrow, that's what we'll talk about some on that one. Now, date of birth 5/24/1951. When's my 72nd year?
2023,
Very good. And my RBD?
4/1/24,
Very good. And my next RMD deadline?
12/31/24.
Awesome. And now 9/15/1951.
All the same answers.
Very good. All right. So all the same answers there. So why is it important to make sure we take out that RMD by our deadlines? Well, if we don't, the IRA owner is subject to a 50% excess accumulation penalty. Just like the other penalty taxes you deal with, it's not the financial organization's responsibility to deal with this, okay? It's the IRA owner's responsibility. They have to remove that timely. It's their responsibility to make sure that's done. And if they don't, they're subject to the penalty. Something that can also occur is they can file their 5329 with that penalty and write a letter to the IRS saying, hey, I messed up, but I've made up for it. I've already taken it now. Moving forward, I'll continue to take it, that kind of thing. Pretty much an apology letter to the IRS saying why they missed it. And the IRS, before recently, I'd never heard of anyone being denied that like removal of the penalty. And I still haven't at this point in time, but I do know they're kind of upgrading the IRS procedures to look into things. So that doesn't mean that in the future it might not be. So yeah, this is a 50% to remove it by the deadline. So what this means is if I had an RMD that was due of $2,000 and I didn't satisfy the full $2,000, I'd have a penalty of $1,000. Okay. Now, if I did satisfy a portion of that, I would only be responsible for 50% of the remaining amount. So let's say it was $4,000. I've now satisfied $2,000 and 2,000's left, 50% of the 2,000 left there moving forward.
What
Is
if you
there-
happen to need to file an extension in your 72nd year of life? Is there an extension on this RBD, or is that a hard no?
A hard no. They get the RBD is the most extension they get, so they get that extra few months there. Now, that's not to say that if they missed it, like I said, they couldn't give that apology letter with their 5329 saying, hey, I had to file extension, there was a family emergency or blah, 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 whatever it was in that case moving forward, and it'd be okay. But the typical answer is no. If they want to do everything to where there's no extra work on their part, they need to take it. So we talked about this being the IRA owner's responsibility. Well, how do we help the IRA owner meet their responsibilities? Well, in the case of RMDs, our only responsibility as a financial organization is to provide an RMD statement. And we are responsible for sending this to each IRA owner, traditional IRA owner, who must take an RMD for the year. Now, there are two possible ways to do this. You know, you either provide the RMD amount or you offer to calculate the RMD amount for the year. So in either way, you might send the amount. If you actually calculate the amount for them, you will do it based upon the uniform lifetime table, which means it's the biggest amount that would be required to be taken. If you offer to calculate it for them, then you would need to know exactly which table they would apply to in that case. This is something for IRA owners only, not a requirement for beneficiaries to receive. A lot of people will do something similar for beneficiaries, but it is not a requirement for those beneficiaries. The financial organization must disclose also when that RMD is due. So is it due by the April 1st deadline, or is it due by the 12/31 deadline? Which one of those deadlines is it due by? And it can be done in any written format. It is due to that IRA owner by January 31st. Now, financial organizations are also responsible for sending that to the IRA owner, as I mentioned, but they're not responsible for sending that RMD statement to the IRS. Why? That information is also included on the 5498, so they do find that information out. So it's just not the separate statement. You don't have to do that.
One caveat here though is the IRS looks at that as an aggregate, right? So let's say they have an IRA here and 4 others elsewhere, but we only know about the one here. It's still the client's responsibility to know what their full RMD is for the aggregate. We can only tell them what our portion is according to our records, right?
Very good. Yes. So that's a great point too. And it brings up another kind of caveat to that. So you're exactly right. You technically might have 2 RMD statements that you receive, each one from a separate financial organization where you have a traditional IRA. They would have their amounts figured out for the RMD for that account. Now, what the IRA owner can do is they can have those separately figured out amounts, and they can combine them on their own side of things, and take them all from one financial organization. Does the other financial organization know they took them all from you? Not necessarily. A lot of them will request that if they are going to take it from somewhere else, that they do notify that financial organization. That way that, you know, if they have any customer service things where they're following up to say, hey, just a reminder, you haven't satisfied your RMD, then they don't have to do that with that individual. But that is a very good point. It is, so say I have $100 due at one financial organization, or reported at one financial organization, and 100 RMD at the other. It's my responsibility to satisfy $200 total. Wherever I do that from is fine, but it's my responsibility that makes sure I take the entire amount. All right. So that's traditional IRA distributions. Now we're going to talk about my favorite kind of distributions. Why? Because there's a possibility of free money, guys. I know. Okay, so the way I like to remember qualified distributions is you have to have both hands in the air. I already mentioned that whenever we have a Roth IRA, they're awesome. Yay! And guess what? We can raise the roof with them. All right. Yes, this stuff is very corny, and I know that, but I promise these images will stick in your head a little better than just basic things. So in order to get a qualified distribution, which means tax-free money, I have to have both hands in the air to raise the roof. In order to get that qualified distributions, I have to have something on both hands helping me raise that roof. What that means is I have to have that 5-year period on one hand. I always like to do it on my right. I have to meet at least one 5-year period for a Roth IRA. A 5-year period begins on January 1st of the year the contribution was made for. We never lose our start date on the 5-year period. Okay, so if I made my very first contribution in 2000, year 2000, and I would get till January 1st of year 2000 as my start date there. Okay, it doesn't matter that from 2006 to 2008, I had $0 in that Roth IRA at that point in time. My 5-year clock still starts January 1st, 2020, whenever I have an IRA that I start contributing to in 2019. Okay, I never lose that start date. So I would have had my 5-year period met. So remember, it's 5 years, January 1st, from the 5 years of the time of the first contribution was made. 4. Now I said 4. So I make a contribution for 2021 here in 2022. My start date goes back to January 1st of 2021. Okay, so that is my 5-year clock. My clock would end December 31st of the 5th year that is done. So technically, I would be considered having it met January 1st of the year after that 5th year. Okay, so any distributions I took from January 1st of the time period after the 5th year would be considered moving forward for that amount there. The qualified reason, we're going to talk more in detail about the qualified reason here shortly, but remember we have to have the year 5 in the hand, 5 up in the air, and 4 qualifying reasons, one of those 4 qualifying reasons. This gives us tax-free and penalty-free money. It's a qualified distribution. We can raise the roof, we get that free money, okay? So this explains that 5-year period in more detail. Remember, January 1st of the earlier year for which the first Roth IRA contribution or conversion was made. So we talked about the Roth contribution side of things, but what if I didn't actually make a contribution? I didn't put new money into the Roth IRA, and instead I just converted it from a traditional to a Roth. That would begin my 5-year period. In other words, it's the first time we put money into our Roth. Okay, that begins our 5-year clock there. We only have one 5-year period per IRA owner. We never lose it there, okay? Now, our 4 qualifying reasons that you're dealing with, we've got age 59 and a half, disability, death, and first-time home buyer, okay? Those are the only reasons that are considered a qualified reason. So if we know something is a qualified reason, we know that automatically no taxes are going to apply moving forward. There are no taxes moving forward, no penalty tax, no any tax that we're dealing with. So our 5-year period, let's do an example on this. Bernie opened his Roth IRA with a regular Roth IRA contribution on April 12th, 2017 for 2016. When did his 5-year period begin?
January 1st, 2016.
Very good. And on what date did he meet the 5-year period?
January 1st, 2021.
Correct. January 1st, 2021. All right, so we know if it's a qualified distribution, we've got both hands in the air. If it's a non-qualified distribution, that means we're missing one of our hands, or maybe both. So that means we either don't have the 5-year period met, or we don't have a qualified reason, or neither. We're just taking money out of our Roth IRA. That would mean that it's going to be subject to taxes and possibly a penalty tax there. Go ahead.
Is that only pertaining to the earnings?
Great
Because can't you
question.
take principal at any time you want from a Roth?
Great
Without
question. Yep, we're about to go into that right here. So that's a good question. So kind of put that on the back burner just for 1 second, and I'll talk about it here in detail right here. So like he mentioned, we can always take distributions from any type of IRA, no matter what. Always take them, okay? One of the biggest benefits of a Roth IRA is that we could always take our contributions out tax and penalty free, no matter what. So this is something that before we get into the cake here that I want to go into detail about, because what this means is that I can put money into my Roth IRA right now and later down the road, take the money out just like a savings account. No issues, no taxes, nothing like that. Why? I pay the taxes at the time of making the contribution. So I'm not subject to anything on that money. Now, if I were to take out that amount plus the earnings, then that puts me into a different category there. And we'll go through that with those non-qualified distributions here right now with this cake. One thing that people don't think about a lot is that because of this advantage of being able to take out contributions at any point in time, it's a great tax sheltered way to have a savings account and make more money on it. Because typically speaking, your Roth IRAs are going to have more interest earned than what you would if you have a savings account or something like that. It's also a great thing for individuals like students who are about to be going to college. So one thing I plan to do with my daughter and my son is that as soon as they have eligible compensation, I want to start making contributions to a Roth IRA for them. Okay. Why is that possible? Well, if they have eligible compensation to support it, they don't necessarily have to put their money in. They can use that on whatever they need, but I could put the same amount into their Roth IRA for them. And then they have that money accruing moving forward. This is a benefit because they could always access that money. Unlike some educational accounts where they might be taxed if they're taking it out for something other than educational expenses, they wouldn't be in a case like this. It also is something that it protects that money from things like when they're filling out their FAFSA to try and get financial aid. They will look at the individual's savings accounts. They will look at everything of that individual, including their parents' savings account. They look at everything. And that means that hurts them when it comes to FAFSA time because they might have money saved in a Roth and not saved in a Roth, saved in a savings account, and it would count against it. Now, if it were in a Roth, it doesn't count against it. So they could have all of their savings in that Roth account and it not count against them for those student loans.
What if your child gets a job like relatively early? Let's say that they start having earned income, taxable earned income at the age of 16. Are they able to open an IRA when they're younger than 18 years old?
Great question. So the IRS allows for it. It's going to be financial organization specific, and it might require some additional information. So for example, they might require the co-signer to be a legal guardian, something like that, to where they have that information on file too. But yes, you can. Technically, you can open up a Roth IRA at any point in time, and as long as you have eligible compensation, you can contribute to it. So for example, I know there's this, say a baby model, someone like that, and Gerber baby. I'm sure they bring in a bunch of money there, taxable earned compensation, that they're bringing in. That money could be put into a Roth IRA, and they could use that later on in life. Now, what they would probably have to have is, like I said, a co-signer or something on that. And that varies according to state law and what's required for each person on what information. And some financial organizations, I wouldn't be surprised to say that they just won't accept it for minors. You just have to find somewhere else.
In terms of your Brady Bunch analogy earlier, with Mike working, and let's say Marcia opens a Roth IRA, can Mike contribute to Marcia's Roth IRA with Mike's earning money as long as Marcia has earned at least that much or more?
Exactly. Yes. So that exact example is perfect. Yeah. He could totally do that. And there's nothing wrong with that. So it doesn't have to be literally that dollar, the dollar amount that they actually received. It just can't go over the dollar amount they received. So it doesn't have to be dollar for dollar the money they received, in other words. So my husband used to work at Dairy Queen whenever he was in high school. Like he started, I think, when he was 15. I was a small town. Dairy Queen was the only place that really hired people like that. And he could have technically at that point in time started putting money into his Roth IRA himself with the money he actually received from Dairy Queen, or his parents could have put money in from their own income just up to the dollar amount he made. Very good. Yeah. So that is a great benefit of our contributions. So remember, 2 ways to get things kind of tax and penalty free. It'd be just a regular contribution if it's a non-qualified distribution, or raise the roof, guys. We have one on both hands met. So I want you to think of non-qualified distributions as a wedding cake for the purposes of this analogy. So if it's a qualified distribution, we already know everything's tax and penalty free. If it's non-qualified, then we go to this wedding cake to decide what is tax and penalty free. Everything regular contribution wise that we contribute will always come out first. So it's like that top layer of the cake. We always take that top layer of the cake off for a wedding, set it aside. That's before we go into the next layers, right? That always has to come out before we go to anything else. So it's always distributed first, and it's always going to be income tax-free and penalty tax-free. That first layer is. I want you to think of them as kind of almost progressively getting worse as you go through it there, because there's possibly more taxes as we go through this layers of the cake. So if we have to enter into the second layer of the cake, so we needed $4,000 and we only had $2,000 in regular contributions. Then we go into our conversion and retirement plan rollovers. We say, has any money been converted over to a traditional and a Roth? And we go in it by year received. So we take out first the money from 2019, then the money from 2020. Why do we do this? Because what it allows for is kind of a penalty exception here if we've met the 5-year period on our conversion or retirement plan rollovers, but we haven't met it as a whole. So, or we have met it as a whole, but we don't have the qualified reason with it. So in other words, if I had it back from 2015, then I wouldn't be subject to the penalty on this section. Now I will always be subject to the taxes on the bottom two, I'm sorry, not bottom two, on the bottom layer here. This layer here, the only thing I might be subject to, the middle layer, the only thing I might be subject to is the penalty tax. So conversions and retirement plan rollovers, we are taxed in the year we convert or roll over the money. Therefore, when we take it out, we don't have to pay taxes again. Now, earnings are just something that accrues. So we've already made it through our middle layer of the cake, and you know what? We're still needing some more cake at the wedding there. So we have to slice into that bottom layer. We couldn't slice into the bottom layer first, right? Because everything would topple over. We have to wait until we've been through all of the layers there, and then we get into the earnings. This is the money, like I said, that just accrues. Once we do that, it's always going to be subject to income tax. In the case of a non-qualified distribution. So if it is a non-qualified distribution, there's no way you're getting out of paying the income taxes on the earnings. No way. Now, it's going to be subject to an early distribution penalty tax if an early distribution penalty tax exception doesn't apply. So it might be subject to both, but always subject to always subject to income tax on that area. So notice it progressively gets worse. The top layer, you've got never subject to penalty and never subject to income tax. The middle layer, possible subject to penalty tax. The earnings, always subject to income tax, possible subject to penalty tax there. Roth IRA owners are the ones who are responsible for determining what portion of this distribution is taxable. And it is their responsibility to do this using Form 8606. If they need additional help, they need to walk through that with a competent tax advisor there.
Is it after age 59 and a half that the entire cake is tax-free?
Only if you have your 5-year period met, you have to have both hands in the air. So yes, though it could be.
As long as your Roth is established when you're like, let's say 53, you're free and clear by 59.5 for sure.
Yep, you got it. So think of it as, like I said, I like to think of it as two separate things. You've got your qualified distribution. If I've got both hands in the air, I'm raising the roof. Everything's, the whole cake I'm going to get is tax and penalty free. If I don't have one hand in the air, then I have to go down the ordering rules side of things, where I see, okay, what layer of the cake am I getting into? What am I dealing with there? So here's an example. Isaac, 36, is withdrawing $1,000 from his Roth IRA today to make a mortgage payment. He opened his Roth IRA with a regular contribution on November 16th, 2010. Does he have a qualified distribution or a non-qualified distribution, and why? So does he have both hands in the air is the first question. Is he raising that roof?
It's not qualified because he's not 59.5, so that hand is not up.
Yep, and he doesn't have one of those other qualifying reasons where disability, death, or first-time home buyer. So you're exactly right there. Good. All right, our IRA distribution questions here, and then we have one more, oh, 2 more pages or 2 more slides, I think, and then we'll do our break for everybody here. So bear with me, we're almost to a break, guys. Which IRS form is used to determine the taxable portion of an IRA distribution? And who is responsible for completing the form?
Is that the 8086, and it is the individual the account owner's responsibility?
Yep, 8606, and it is the IRA owner's responsibility for completing that form 8606. When non-qualified Roth IRA assets are distributed, so remember, we already know it's non-qualified. Which types of assets are subject to the early distribution penalty tax?
Conversions and retirement plan rollovers and the earnings.
Yes, very good. Yes, both of them are possibly. You know, we might have an exception, but possibly subject. Yep. When non-qualified Roth IRA assets are distributed, which types of assets are subject to income taxes? Now remember, think through, have we already paid the taxes on this?
Earnings.
Yep, earnings, correct. The other 2 we pay at the time of contributing. When traditional IRA assets are distributed, which type of assets are subject to income taxes and the early distribution penalty tax? Traditional, remember this key word here, traditional IRA assets.
Deductible contributions and earnings.
Yes, very good. A lot of people forget the earnings on that one for some reason. So very good. Yes, so all taxable money there on the traditional IRA. Now, my question to you guys, it's not on there. What is the way to get money tax and penalty free? What do I have to have?
Be age 59.5 and a qualified event.
Or a qualifying event, and what else?
The 5-year rule.
Yep, so 59.5 or older, first time home buyer, disability, death on one hand, and our 5-year period met on the other hand. So we have to have both. Now, does that mean I have to be 59.5 and disabled? No, I have to be one of those 4 qualifying reasons, okay? So just as long as one of those reasons meet, you're okay there, and it is qualified. Very good. Here is our traditional IRA withdrawal authorization. Typically speaking, a lot of people use that. You've got the IRA owner's information in part 1. Notice the withdrawal information goes through part 4, and it tells you what type of withdrawal you're taking. It's a normal withdrawal. Do we have an early withdrawal? What exactly is the reason for doing that there? And then you put the withdrawal amount and the withdrawal date there on that information. As a financial organization, we're required to report those distributions on the 1099-R for distributions, and it is due to the recipient by January 31st. It's due to the IRS by March 31st if you're doing it electronically, February 28th if you're doing it paper version. And it is the year following that. So this is a 2021 one. It'd be January 31st, 2022 to the IRA owners, and so on from there. You must do that for traditional Roths and simple IRAs, and they each have their own one. If it's that Roth, it's a different account that you're dealing with, things like that. You have different account numbers for those. But there's a question?
Yeah, I was asking about the mail-in, as long as it's postmarked by February 28th.
That one's not very specific on it. It just says it has to be due to the IRS by February 28th. So I think on that one, I would play it on the safe side and make sure the IRS literally has it by February 28th. Just because I'd rather not skirt the lines on something like that. Now, to fill out this 5329 1099-R, we've got the gross distribution amount in box 1. We then have the taxable amount in box 2A. Generally, this will match box 1 for traditional IRAs. So in other words, if I have a distribution of $1,000 from my traditional IRA, I would report it in box 1 and also report it in box 2A, $1,000. Why is that entire amount taxable? Not necessarily, but it's the IRA owner's responsibility to determine that. Therefore, that's why we would mark the next box of taxable amount not determined in box 2B. If it's a Roth IRA, 2A will report 0. I'm sorry, not 0. It will leave blank, which is different than 0. Okay, so make sure that it is blank here for a Roth IRA. Why? Because we still haven't determined that amount, but it is the responsibility of that IRA owner to make sure that's done. Typically speaking, most of the time you're going to see this box checked unless it's a special type of distribution. The total distribution box is exactly what it sounds like. If you're taking all of the money out of that IRA, you put the total distribution checkbox in. And then we put the federal income tax withheld in box 4. Box 4 here, it might be, we'll say we did the $1,000 distribution and I did 10% withholding. I've got $100 listed right here. That $100 would be listed here. And I would still report $1,000 up here, even though I only received $900. So even though the amount in hand might be different than the gross distribution amount, if we withhold, we still report the entire amount that actually comes out of that IRA there. And then finally, box 7 is where we report our distribution code. That is going to be specific to the type of distribution being removed. You also are going to check IRA SEP or simple on this box here, if it falls into one of those categories. If it's a Roth, that obviously wouldn't be checked because it is not a traditional IRA SEP or simple. All right. I've got the distribution codes here. This is before our running review. I'm going to go ahead and let you guys do a break now, and then we'll go through our distribution codes here right when we come back. So let's meet back here. Is everybody good at, see, 2:50? That gives you a 15-minute break.
Sounds good.
All right. So we'll meet back here and go through those last few items here in this section. All right, and welcome back, everyone. We are going to finish up this distribution section here and then get into portability. So this is one of my favorite parts, is talking about the reporting codes. Why is reporting fun? No, not at all. No one likes reporting. Why is it my favorite part? Because I make this part a little fun for you guys, or at least I try to. As always, my jokes are thoroughly cheesy and over the top. I understand that. But whenever you go to report something, you'll thank me for this whenever you get to that important part there. Okay. So we mentioned that box 7 there, that 1099R is where we're going to put a important code. What does box 7 do? It lets the IRS know, hey, are they going to be subject to a penalty? What type of taxes are we looking at? What is going on with this type of distribution? So the first code we have is code 1. What this is for is an early distribution. So in other words, this means an IRA owner is under the age of 59 and a half, and they have no other penalty tax exception. So no known exception. When do we use this here? Well, again, with the dating myself, everybody remembers the original Jurassic Park, right? Surely I've got some Jurassic Park fans out there. Please tell me there's some Jurassic Park fans.
Heck yeah.
Okay, good. And the original Jurassic Park, you know, was a great creation of its time. So how do I remember code 1 here? Well, I like to remember, and you have to imagine it with me here, guys, okay? I want you to think really hard back to this scene. There was a scene where Wayne Knight was gone, and he was the computer guy behind all the stuff here that controlled the park, right? And he was gone. He was off. I think he was already attacked by the little dinosaur at that point in time. That was so cute at first and turned evil. But he'd already been attacked, so he wasn't at his computer. So Samuel Jackson is sitting at Wayne Knight's computer, and you know, he's furiously hacking, typing on this computer, trying to figure out how to get into Wayne Knight's computer to get everything worked out and shut the park down the way it needed to be done. Wayne Knight had this password protection thing set up on his computer, and it would pop up a little image of him. And he's sitting there and he's wagging his finger and he goes, you didn't say the magic word. And it's the most annoying sound ever that I remember. And it was just so, I can't even make it the way it was. But anyways, the point is it's, you can't get in. You didn't say the magic word. You didn't do the right thing. Remember code 1 is this. It's the IRS wagging their finger at us saying, you don't have a reason we accept to get out of that penalty, okay? You're subject to that penalty. Or the no, you're subject to that penalty, okay? Code 2 is going to be for specific distributions. You've got that direct conversion, an IRS levy, substantially equal periodic payments. What are all of these things? These are all things that as a financial organization, you are going to know they're doing. Substantially equal periodic payments, they're going to set it up with you. IRS levy, you're going to have that document saying the IRS is levying their account. A direct conversion, you're physically moving the money over directly to another Roth IRA from there. So you know that. So what this is, code 2 is for peace, because you know this is our peace symbol. And we have peace with the IRS because we are under age 59 and a half. We're doing a distribution, but it's for one of these 3 reasons. So the IRS says you're not subject to the penalty. You have peace with us. You're good to go. Code 3 is for disability. If the IRA owner is under age 59 and a half, I want you to look at this like an okay symbol here. Whenever you hold your hand up like an okay symbol, it kind of looks like a wheelchair, right? We got the circle and then the line here. Circle, line, kind of like a wheelchair there. So that's your code 3. That's what's going to be for disability. Remember this one, we would have that proof that we would keep on file, something like that Schedule R, letting us know that information. Code 4 is going to be for death. I like to remember this one as Code 4, IRA owner no more. In other words, the IRA owner has passed away. We are now making a distribution to the IRA beneficiary. Code 7, lucky number 7, right? Code 7 is for that normal distribution. That means that we are an IRA owner who's age 59 and a half or older, which means codes 1, 2, 3, 4, none of those will be used if you are an IRA owner taking a distribution and you're over the age of 59 and a half. So even if previously, when you were 58, you were taking code 3 distributions, you're now a code 7, even though you're still disabled. Even if at 59 and 5 months and 22 days, you were having a code 3 distribution, you're now at a code 7 once you reach age 59 and a half or older, okay? So there is that distribution age, that code 7, you're lucky number 7, you are finally at the age you can take distributions penalty tax free.
Is there
Any
a 5 or 6?
Go ahead.
Is there a code 5 or 6?
Good question. So there is a code 5. Code 5 is actually for a prohibited transaction. So it would mean they did something wrong with their account and you're reporting that distribution from there. I remember that one because it's a no-no. You like to think of it as like almost like a slap in the face, you know, or a slap on the hand, full hand slap, that kind of thing. So it's something they should not be doing. Code 6, I do not know of anything that is a code 6, oddly off the top of my head right now. Yeah, I can't, I'll have to look that up here in between whenever y'all are looking at something just to make sure. It might be retirement account related rather than IRA related. That might be what it's used for. So good question. So these are for traditional IRA distributions, okay? So we use numbers with traditional IRAs. When we get into Roth IRAs, they're a little fancier. So we get to use letters instead of numbers. Now, code 2 is always going to apply if it's an IRS levy to IRAs, Roth, or traditional, no matter what. Q, guess what Q stands for, guys? What do we call it? What do we call a distribution when we raise the roof? I almost gave it away.
Qualified.
There you go, qualified distribution. So Q stands for qualified, which means as a financial organization, we have the proof that both hands are in the air. They've met their 5-year period and they meet one of the 4 qualifying reasons. All right. Now you typically won't report a Q if it's a first-time home buyer because it's not really something you can prove. That's something that they would handle on their own side of things to make sure they get it reported as that. But they would still get the benefit of it. You would report a T if they have the 5-year period met and they're doing the first-time home buyer, and from there they handle it. A code J, well, we'll do J last. A code T is going to be when no time has been met, T for time, but no time has been met, or we don't know if time has been met. So the 5-year period, we don't know if that 5-year period has been met or not, but we do have one of the qualifying reasons. So we were either 59 and a half, death, disabled, that kind of thing there, okay? Or first-time home buyer, which you're dealing with. So T would be reported if we have one of the qualifying reasons, but that 5-year period we either don't know about, so the funds came from another institution, or we know they do not have time. J is for literally everything else. Junk, for all the other junk is how I think of it, okay? So Q we know is qualified, T is for no time or unknown time, and J is for all that other junk. Now, we've got our running review here we're gonna do real quick. With this running review, we've got distributions. What taxes might the IRA owner be subject to upon distribution? There's 2 types of taxes. What are the 2 possible taxes that they might be subject to?
penalty, early penalty, or,
Income tax?
There you go. Yep, those are the two. Income tax, which would be that federal taxes or state taxes, and that early distribution penalty tax. What age must an IRA owner begin taking distributions?
70 and a half.
This is interesting.
Yeah, so
Are you
originally
following?
72.
Are you following?
70 and a half if they were born before July 1st, 1949. If they were born after July 1st or on July 1st, 1949, age 72. Okay, that's when they're required to begin those distributions, or that's when one is required of them. When must a Roth IRA owner, now I said Roth IRA owner, begin taking distributions?
You never have to.
Good. Yes, and that's what I was going to say. We kind of skirted over this one, but this is where I want to emphasize it. A great benefit of that Roth IRA is we are never required as the Roth IRA owner to take distributions. Never. I mean, I could be 100 years old and I still don't have to take money out of my Roth IRA if I don't want to. Now, once it goes to your beneficiaries, that's a different story. But as the owner, you're never required to take distributions. Okay? So when do we report to the IRA owner with that Form 1099-R? When is it due? To the owner.
January 31st.
Very good. Now, what about the paper version of the 1099-R to the IRS?
January 31st.
Paper version to the IRS is going to go February 28th. And then electronic version to the IRS is due when? March 31st. Thank you. Somebody looked it up for me. Distribution code 6 is a section 1035 exchange. So yeah, not something you would deal with at all in the IRA world. Not even sure where that is dealing with, honestly. Thank you for looking for that for me, Joanne. All right, now we're to the IRA portability section. This section, we're going to talk about all the ins and outs of how to move money between IRAs. We're going to differentiate between the two methods of moving IRA to IRA, which would be IRA or rollover or a transfer, how each one applies, what goes on with it. And we're going to distinguish between a direct and an indirect rollover between IRAs and employer-sponsored retirement plans. That sounds like a lot of rollovers, I know, and it tends to make things confusing, but we have some imagery here to hope to help with that. So let's get going on that if you guys are okay. So IRA to IRA portability. That means we can move money in two ways specifically. The first one being whenever we're moving money IRA to IRA, the two types we're dealing with are the transfer and the rollover. This would mean we're moving money like to like account. So traditional to traditional, Roth to Roth, simple to simple, that type of thing. Simple is also considered a traditional after that 2-year period. So it could be transferred or rolled over to a traditional or back and forth, but it does have to meet a 2-year period there at the time of the first contribution. So what we're going to do here is we're going to use an image I want you to think about. Whenever we are dealing with a transfer, imagine two like cups. This is traditional to traditional, Roth to Roth. Money's moving exactly the same to the exact same type of account, right? These cups look exactly alike here. With a transfer, I want you to imagine us taking the money and pouring it directly into the other account, okay? So that means we're dealing with us as a financial organization moving the money directly into the other type of account, whether via a check made directly payable to another financial organization or something of that fashion. Whereas a rollover, you tend to get a little stickier. That IRA owner gets their hands on the money in between. So a rollover would look a lot more like, here's one IRA, Just kidding, I didn't actually split it, guys, but you get the point. So it would be, there's some IRA owner getting the money in the middle, or for example, me getting the water there in the middle and then spitting it out onto the other side. What this does is we don't know necessarily if all the money or all the water is going to make it over to the other cup. Because of that, we have to report it differently and handle that information differently moving forward with that rollover. So remember, if you keep those two images in your mind, you can kind of keep track a little bit about what's what. So a transfer is going to go between like IRAs, those like cups, both the same type of a cup. There is no constructive receipt of assets. What that means is the IRA owner doesn't get to touch the money personally. They don't put it into their checking account. They don't put it into their savings account. They didn't actually receive a check made out to them. They have no access to those funds, okay? An unlimited number of transfers can occur. So no matter how many times we do a transfer from IRA to IRA, we can always do it again. There's no set amount on that. And withholding rules do not apply because the distribution actually doesn't occur. It's just the movement of the money. Therefore, it is also non-reportable. It is non-reportable because no distribution actually occurs. So what you might see with the transfer is someone requests the money to move to another financial organization. You move that money directly via wire transfer. Or you make a check payable to financial organization B on behalf of Jane Doe's IRA. And then you give that check to Jane Doe, or you mail that check. Either one of those would be a transfer because technically Jane couldn't cash that check, right? She has it in her hands, but it has to go to the other financial organization. So it's that direct movement of money. When the IRS sees it as being safe, they know there's no risk that they're not going to have that money put back into the IRA. There's no risk of the IRA owner getting some of that money tax-free. So that's the point of the transfer. It's the easiest method of movement, the recommended method of movement, unless the IRA owner wants access to those funds. A rollover still occurs between like accounts. So this cup to the other cup, looking the same. Different being is their constructive receipt of those assets. The IRA owner gets their hands on the funds. They could technically take it to Kohl's down the road and spend it on whatever clothes they wanted to spend it on. They could buy a house with it. They could do whatever they want to do with it. It is constructive receipt of those assets. They can use those funds in whatever manner they want. Whenever I receive that water in my mouth, I could technically swallow as much of it as I wanted and spit out whatever I wanted there on the other side to make it a rollover. Okay? So that's why the IRA owner has access to those funds. So what they have developed is something called a 60-day rule. That means technically they only have 60 days to put that money back into the account. What that means is that 60 days following the day they physically receive the assets to deposit that money into another account. And I said physically receive the money. Therefore, that means if I mail the check to you, even though I mail it on today, today's 18th, right? Or the 19th. Today's the 19th, January 19th. But you don't get it until January 29th in the mail. Then the day after January 29th is going to be your first day, day one. It means if you're on vacation, your 60-day period doesn't resume until the day after you get back from vacation and receive that check. So that is one of the things about the 60-day rule is there's a little bit of an argument about it. You can prove that, and that's between them and the IRS, that they made that IRS rule. All you're responsible for is asking the questions there, and they have to accept that they are eligible for that type of money movement there. And if the IRS were to ever audit, they'd need to have the proof that they were on vacation or whatever that made them not meet that 60-day rule. The 1 per 12-month rule, that is going to be specific to IRA money. And what that means is that you can only have one rollover distribution in a 12-month period. So that's not year specific. It's not one in 2021, one in 2022. it's a 12-month period. And I said rollover distribution. So I can only take one distribution out of an IRA and count it as a rollover to go back in. In other words, I could have taken 12 distributions in the year, but only one of those distributions can be rolled in to my IRA. And it's a one per IRA owner or tax identification number, not type of IRA, not per IRA, it's per IRA owner. Again, IRA owner's responsibility to keep track of. We normally suggest having that question there, which we have a rollover form on our rollover information that will say, hey, do you certify that you're eligible for this rollover? Have you met this criteria? And they say yes. And then it's on them. That way we're kind of proving that it's on them too, and covering all the bases. Because it is an official distribution, withholding rules will apply. So they need to make a withholding election, or the mandatory withholding will apply there. There is an RMD restriction. What this means is if you have a required minimum distribution due, you are required to take that distribution, and the money cannot be put back into an IRA. So I have a $2,000 RMD that's due. Prior to rolling over any money that I want to, I need to keep $2,000 out of that IRA. And then I can do whatever I want with any additional distributions. This also makes a little more confusing now that you can contribute after the age you're making RMDs. So technically, someone could have a distribution of an RMD that is $2,000 and then later go in and make a contribution of $2,000. This is not the same thing as a rollover. They took the distribution of that $2,000 and they're therefore taxed on it. As long as they have the eligible compensation, they contribute whatever money they want to do from there. All right. Now they couldn't take that distribution and then roll over that money. Therefore, they wouldn't be taxed on it. They are required to take it as a distribution and that money stay out.
Is that bound to the $6,000 limit rule in any way?
The rollover amount that you can do?
Yeah, since it's a type of contribution when it goes back into
Good
the IRA.
question. Yeah, that's a great question. So contributions, think of contributions as new money going in, and that's going to be the ones that are subject to that eligibility limits and rules and the eligibility or the amount of that you can contribute. Portability, once we get into portability, the movement of money that's already been contributed, so it's already sitting in an IRA, they've already met the eligibility criteria, they've already met the limits, therefore they can do whatever amount that they want to do from there. So technically I had a $50,000 account, I could transfer the whole thing over to one financial organization. There'd be no issue. Or roll over the entire amount if I wanted to do that full distribution. Great question. With rollovers, you do have to make an irrevocable designation. This one is slightly a harder irrevocable designation than the one we talked about for that prior year, in the sense because there's no revocation. Well, I guess there technically revocation still could apply if that's how you open the account. Revocation is like the only thing that would allow for you to get something like this back when I say irrevocable. All right, that's the only way around these things here. Irrevocable rollover designation means I'm saying, yes, I'm rolling this money back in. I can't later say, oh, I don't want to roll it back in and I want to count it now as a distribution. No, it's back in now. Then anything you do from there will be another reportable transaction.
And you'd have to wait 12 months to roll that over elsewhere.
Yeah, or you can do a transfer. Yeah, exactly. So rollover starts with an R, ends with an R, right? We report this transaction when it comes out and when it goes back in. So we report it on both ends of that rollover. Remember that. Transfer doesn't start with an R. It is not reportable. It is the only one of these ones we're going to talk about here in all of portability that is not reportable. Okay. Everything else is a type of rollover, and therefore it'll be reported when it goes out and back in there moving forward. Okay, so I want you to, in the chat feature here, or talking, however you want to do it, do T for transfer, R for rollover, N for neither, B for both, okay? So type that in whenever I ask the question, and we're going to see what each type is here. So when do withholding rules not apply?
Transfer.
Good. Good. I'm getting a lot of T's. Very good, guys. What about age requirement? Which one has an age requirement?
Neither.
Very good. Neither. And that's because, remember, it's old money just being moved. No constructive receipt of assets.
Transfer.
Very good. We don't get our hands or mouth on the money in the middle. What about irrevocable designation? Very good. Rollover. Good job. What about that 60-day rule? Which one has a 60-day rule?
Rollover.
Awesome. Rollover. Which one has no reporting requirements?
Transfer.
Yes. And which one has an eligible compensation requirement? Very good. Got one answer. There we go. Neither. You guys are right. Neither, because we've already met that with when we originally contributed. Now we're just moving. Which one has an unlimited number of transactions?
Transfer.
Awesome. What about that 1 per 12-month rule?
Rollover.
Very good. Rollover. Awesome job, guys. So that's our transfer versus rollover. Remember, these are one-word transaction types. One word. That means there's only one type of account involved. So it's like accounts, okay? That is an important thing to remember before we move forward. So it's the same kind of cup, the same kind of thing we're dealing with, like accounts, one-word transactions, okay? Now we're dealing with rolling over employer-sponsored retirement assets to an IRA. So that means, as you hear it already, yes, two types of accounts here. Employer-sponsored retirement plans, here's my water bottle, and my IRAs are still my cup here. So I'm moving money from point A to point B or point B to point A. In this case, I'm doing my employer-sponsored retirement plan to a traditional simple or Roth IRA. In doing so, I have two types of transactions I can do, a direct rollover or indirect rollover. Notice two types of accounts, two different kinds of accounts here. And we're dealing with two-word transaction types, direct rollover or indirect rollover. Okay, so these move very similar to a transfer versus a rollover. A direct rollover is exactly what it sounds like. You take the money from the employer-sponsored retirement plan and pour it directly in there. The indirect rollover is when you're going to take a sip of that in between, spit it out on the other side. Okay, so in other words, that IRA owner gets their hands on the funds in the middle there. You can indirectly or directly roll over assets from that employer-sponsored retirement plan into a traditional, simple, or Roth. Those eligible plans you might be dealing with are going to be qualified retirement plans that fall under 401A, 401K plans, 403A plans, 403B plans, governmental 457B plans, and what you might hear of as a TSP, which is a federal thrift savings plan. The one big thing I always want to mention is anytime you're dealing with portability and simple IRAs, remember you have to have the money in the simple IRA for at least 2 years prior to moving it. Let me clarify that. 2 years from the time of the first contribution. So as long as that contribution was at least 2 years ago, we can move the money however we need to. But if it hasn't, then it's going to be subject to an additional penalty there that you're dealing with, and you don't want to have to deal with that moving forward. Okay. So that's the direct and indirect rollover. The rolling over from a designated Roth account assets, that is something differently. So whenever you are dealing with a qualified retirement plan, for example, we have a 401k plan with the census. And what it is they have money that is designated Roth money that you put in. So you pay the taxes on it at that point in time. That money can technically only be rolled over to a Roth IRA. It can't go into pre-tax money, can't go into a traditional. Why? I don't want to pay the taxes on it twice, do you? I don't want to have to track it twice, do you? So they just made it a no-go. It's not possible, okay? We can do a direct rollover to a Roth or an indirect rollover to a Roth, whatever we may want to do from there, okay? Now, something also important to note is that 5-year clock is different between the designated Roth account and the Roth IRA. They do have separate 5-year clocks there that you're dealing with. So a direct rollover, let's talk through what makes it a direct rollover. It is going to be between a retirement plan and an IRA. The plan administrator has to determine that eligibility. So that is different than our regular rollovers, right? It's the financial organization doesn't determine that eligibility. It's IRA owner's responsibility. With qualified retirement plans, you actually deal with someone who is in charge of making sure they follow all of the rules and handles all of the plan assets there. So it's that plan administrator's responsibility to look and see if they're eligible to roll that money over. It's not an R&D, things like that. Are they eligible for that rollover? No constructive receipt is involved with the direct rollover. So direct movement from that qualified retirement plan into the IRA. No 60-day rule because there's no constructive receipt. So that means technically they could have that check written from the qualified retirement plan and not put it into the IRA for months. The only possibility you might be dealing with is you might deal with a stale dated check at some point in time, but that would be the only thing kind of holding them back from how long that you're dealing with it. There is also no 1 per 12-month rule and no mandatory withholding. So there's no official kind of distribution in that sense whenever you're thinking about it that way. You also have an irrevocable rollover designation here and a reportable transaction. Remember, we have the word rollover in it. It reports when it comes out and reports when it goes back in. So we have to report on both ends there. You will see this as a check made similarly to a transfer. It will be directly payable to the other financial organization, the financial organization's IRA on behalf of that IRA owner, something like that. That will be how that check is made payable there. Indirect rollover is going to be between retirement plan and IRAs. And it's the IRA owner's responsibility to determine the eligibility now. Because think about it, now it's that IRA owner's responsibility because they got their hands on it in the middle. So they have to know if they can put the money back in to the IRA. There is constructive receipt of assets from that IRA owner. And because constructive receipt of assets occurs, the 60-day rule also occurs. They have to get it back in within 60 days. The only one that has a 1 per 12-month rule is IRA to IRA related. Anything dealing with a qualified retirement plan moving to an IRA are not subject to that 1 per 12-month rule. There's a mandatory 20% withheld on the distribution side there from the qualified retirement plan, which means that if the IRA owner technically doesn't make up that 20% going back in, they're going to be taxed on the 20% that was withheld. So for example, a $10,000 distribution, $2,000 withheld there. If we don't put back in the full $10,000, even though we didn't receive $2,000 of it, we're going to be taxed on that $2,000. Granted, we already have it sitting there with the IRS in our piggy bank, but it's just important to note that they would be taxed on it as if they received it there.
And then it
And
was
IRA
more back in
Go
the
ahead.
form. refund?
Say that again.
And then that $2,000 that was withheld might likely come back as a refund?
Right, yeah. Yeah, it's exactly right. So if we withhold it, that 20% is with the IRS and our piggy bank, right? So we can't technically use that 2,000, but we could make up the 2,000, put a full 10 in, and then like you mentioned, you get that back on the your tax refund then, because you did roll over the full amount. And because it has the word rollover in it, it's reportable on both ends, right? Going out and in. We do have to report that distribution there and the contribution back in. We can also roll over assets in the reverse order with a direct rollover or indirect rollover. So in other words, from the cup into the bottle, we can go from an IRA into an employer-sponsored retirement plan. It does accept rollovers from these or indirect rollovers of any taxable distribution from the traditional or simple IRA there. It can be moved over. Okay, so we can do that from that traditional and simple IRA to an employer-sponsored retirement plan there. You are capable of doing that. With the direct rollover in this scenario, everything is pretty much the same. Just note that the big difference here is it's saying only between that traditional or simple and the retirement plan and pre-tax assets only. Still, everything else remains the same going forward. So it's just pre-tax assets only that can come over from the IRA going to the qualified retirement plan, not after-tax money. The indirect rollover, again, the only difference going this way is going to be that pre-tax assets only there moving forward. All right. So one way to remember this is the big thing here is that Roth IRA money, once it's in a Roth IRA, it cannot go into any other type of account other than another Roth IRA. Something I really like referring to for people is publication 590A. And you can just do a Google search for publication 590A, but on page 22 of publication 590A, you have this awesome chart that kind of goes into detail and talks about where the money can move and how the money can move from there. The other chart that is a really good resource is, I believe it's on page 35 of my job aids. So if you want to do a search there, it might be 34 of yours. I'm not sure, but it's the transfer and rollover chart. So it's right there in that 30 range there. Check for there. You can look at that transfer and rollover chart, and it literally tells you yes, no, maybe, if the money can move, and what type of money can move, and is it subject to anything specific. Good question. Someone's asking, so can you get the cream out of the coffee? No, not necessarily here. So in this case, if we were to move money from the traditional IRA that had both pre-tax and after-tax assets into a qualified retirement plan, the only money that could go into a qualified retirement plan is the pre-tax assets. I guess so. I see what you're saying. So in a way, you can kind of have the non-deductible money there. But the problem being is that the distribution would be hard to do in that manner. So I would say, I don't even know if someone would accept it if you have both types on that. That's a good question there. If you have both types and you're trying to do that rollover from that manner. One way you see people kind of getting the cream away from the coffee in a situation like that would be going the reverse way. So say your IRA has, not IRA, your qualified retirement plan has both pre-tax and after-tax money in it. At that point in time of doing the rollover, technically you could separate the two out. I don't think you can do that the reverse way though. So going from the IRA to the Roth, because there's no way to separate that money out into anything there. Good question. All right. Transfers and rollovers. We have an example here, pages 67 to 68. Let's look at that real quick. All right. So what we have here is Burl Smith, age 38, would like to move his traditional IRA assets from Pacific Princess Financial Organization to his traditional IRA at your financial organization. So we're moving from traditional to traditional here. What are Burl's options to that IRA?
Transfer or rollover?
Very good. 1 second here. Okay. Yeah, so he could do either a transfer or a rollover there is what you're dealing with. So why? Because we've got like-to-like account, direct rollover, and indirect rollover aren't an option. So it's one type of account, one word transactions. Burl has a check payable to Burl Smith for $15,000 from his IRA. If he rolls over $10,000 into his IRA, what are the tax consequences of this transaction?
5,000 of it is taxable.
Awesome. Yes, the amount not rolled over is subject to income tax, so that 5,000 is subject to income tax. One other thing to remember is because Burl is under age 59 and a half, that taxable portion is now also subject to the early distribution penalty tax. What are the tax consequences if the $15,000 check is made payable to your financial organization for the benefit of Burl Smith?
No consequence.
Very good. There are no tax consequences because the check is payable to the financial organization. So it's moving directly. It's that transfer. All of it's getting there safely. Catherine, age 68, is moving $200,000 from her 401k plan from her former employer to her traditional IRA at your financial organization. What are Catherine's options for moving her 401k plan assets to your financial organization?
Direct rollover.
Yes, that is one of them. Direct rollover. Anything else?
Indirect.
Very good. So two types of accounts, 2-word transaction there we're dealing with. Okay. If Catherine requests a distribution of 200,000, how much will she receive? So if she requests a distribution of 200,000, how much will she receive? Very good. Yes, $160,000. Why? Because we're not moving the money directly, which means that we're going to have 20% withheld. Therefore, 200,000 is going to be withdrawn, 40,000 withheld, 160,000 is what Catherine's going to receive. What are the tax consequences if Catherine rolls over $160,000 of her 401k plan assets into her IRA? So she took a distribution of 200,000, but she only rolled over 160,000. What are the tax consequences of that? So of
What
that,
starting balance?
go ahead.
What was the starting balance again?
$200,000 distribution, and she's only going to roll over 160,000 of that money.
So she'd be taxable for the 40,000?
Correct. So of the 160, she's not going to be taxed on that she rolled back in, but the 40,000 that didn't get put back in, she would be subject to income taxes on. Now, she's not going to be subject to the early distribution penalty tax on the taxable portion because we already said she was age 59 and a half or older. If she was under that age, she would be subject still on that amount too. So what if the check is made payable to her financial organization instead of Catherine?
No tax consequence.
Very good. She's going to receive $200,000 and it's a direct rollover, so we're not dealing with any tax consequences there. So whenever you receive a check, I want you to start thinking of it as there are certain questions I need to ask. The first question being, where did the money come from and where is it going to? Okay, so that first question is going to help us determine if we're dealing with like-to-like account or like-to-unlike account. So in other words, if we have a 2-word transaction or a 1-word transaction. Okay, the next question that we ask there is, how is the check made payable? If it was made payable to the financial organization for the benefit of the IRA, we know we're dealing with either a transfer or a direct rollover. If the IRA owner is bringing in a personal check, that means it's coming out of their pocket, which means that IRA owner gets their hands on the funds, and we're going to be dealing with a rollover or indirect rollover. So let's do a couple quick examples here. Let's say someone came into the financial organization and they want to move their money into your IRA here, your traditional IRA. What's the first question we ask?
Where's the money coming from?
Okay, in this case, it's coming from another traditional IRA. What's the next question to ask?
Who was it made payable to?
All right, this one was made payable to the IRA owner, but they actually brought in the check and it's made payable to the IRA owner.
That would be a rollover.
Very good. Yes, and that one's kind of tricky because even though they brought in the physical check that was given to them, they had access to those funds even though they did nothing with them. So it is a rollover and it's going like to like. Now, same situation. The only difference being it was from a 401k plan. Everything else is the same. It's going to be that indirect rollover. You still report it as a rollover, so that part doesn't really matter. It's just for your reference. Now, if they brought in the check, but it was made payable to your financial organization, IRA to IRA, you're dealing with that transfer there. Does that make sense to everyone? Differences there?
Yep.
Okay, great. We're almost there, guys. Just a few more slides. You guys have done great today. So this next slide here, it is showing our contribution and investment selection form. As I mentioned, the only time a contribution is technically required, contribution form is technically required. It still isn't technically required if you report it elsewhere, I guess I should say. So a contribution form is never technically required. Highly recommended, not required. On this form, you can put the contribution amount and the contribution date there. If you're reporting it as a regular contribution, this also allows for you to report the tax year. Remember, if they're doing a prior year contribution, if we don't use a contribution form, they need to note elsewhere in writing somewhere. Now, when you get down below the regular contribution, you have a rollover and a transfer. There's no way to designate either of these for a different year. It's designated them for the year that the contribution goes in, okay? So we would select the rollover for a regular rollover or an indirect and direct rollover. All 3 rollover types would be for that rollover selection. Transfer is the only one that's going to be different that you're going to check that different box on. Reporting rollover contributions. Just like everything else, we have to report when we have money that is being put into that IRA and coming out. Rollover contributions, as I mentioned, we report on both sides of things. This 5498 is still where we're going to report this information, and it's going to be sent to the IRA owner by May 31st of that year, okay? We will, instead of putting it in box 1 or box 10 like we do with regular contributions, rollover contributions get reported in box 2. We report the contribution amount and the year that it was made in. So if I distributed it in 2021 at the end of the year and I rolled it over 60 days later, technically my rollover contribution is going to go on that 2022 form there, okay? So that's the significant difference there, is we report it there in that year that it goes in, not necessarily, there's no year 4 in that kind of situation. We're going to also enter the fair market value box in box 5, and then mark the appropriate box for box 7 is an IRA SEP simple Roth IRA. That's for the rollover contribution. Okay, remember I said you do report it when it goes out and back in. Oh, so you'd report the distribution according to whatever code would apply otherwise from there. So it could be a 1, 2, 3, 4, or 7, either any of those, J, Q, T, any of those, and you can report it as a rollover contribution going back in. So whatever situation applies to that individual, we report that distribution on the 1099-R for. Question here, where would we report transfer on this form?
You don't need to report a transfer.
Correct. Yes, very good. Also, another thing that's different is we do not need to submit an account statement to the IRS just to report rollover contributions to their IRAs. So that is not a requirement there. Okay. And now we have our running review here. We're right there at the end, guys. So portability, what are my 4 methods of moving assets with portability?
Rollover, indirect rollover, direct rollover.
Transfer, rollover, indirect rollover, and direct rollover. Awesome. Good job. All right. You guys made it. And we made it there a little early. You guys did a great job today and keeping up and understanding and everything like that. Are there any questions?
The dinosaur in question was a Dilophosaurus.
Ah, thank you. Thank you. Very good. Well, I thank you all for attending today. And if you have any reviews, or you might, I think you're going to be emailed a review, a survey to ask how you thought of the course. I hope you all enjoyed it, and I hope my not so, okay, they're totally cheesy. I'm not gonna lie. My cheesy methods help you remember some of those things moving forward. Again, thank you all from Ascensus and Michigan Bankers Association. We really appreciate your attendance here. And some of you, I might be seeing you again tomorrow. Stephanie, do you have anything to add?
Yeah, thanks, Elena. Oh, go ahead, Andrew.
I was going to ask, will we have access to this slide deck presentation? Like, was that in the email, or is this a separate file that we can't have access to?
Elena, I sent them the PDF. So I think, is that a little bit different than yours?
The PDF, yeah, it's going to be, the PDF will be slightly different than the slide deck. Let me ask on that, and then you can send an email out if that's okay with you, letting them know if you include it there.
Absolutely. Well, thank you. Great job. I learned a lot as well. Look forward to seeing everyone tomorrow for advanced IRAs. And you're welcome to join us in person as well in Lansing if you're interested in nearby and want to come over. So have a great night, and thanks, Elena. Well done.
Thank you. Bye.